Good afternoon. We are on the record in 53rd Circuit Court for the County of Sheboygan. We are providing public access to our docket this afternoon, both in the courtroom and also online. Our first case this afternoon is People of the State of Michigan versus Trevor McLoud. It's file 23-6748FH. Counsel, you want to state your appearance, please?
Anthony Julian on behalf of people.
Okay, Mr. McLeod, are you present, sir? Yeah. You want to come on up to the table here?
All right, reserve all my rights.
That's fine, I'll. All right, so Mr. McLeod, this is the time and date scheduled for a circuit court arraignment. The case having been bound over to this court by the district court. So you're here representing yourself today, is that correct?
Yeah.
What's that?
Yep.
Okay. So I'm required by law to make sure that I've taken an initial waiver of your right to counsel in this court. So I covered a pre-trial hearing in the district court, so we talked a little bit about this, but now it's up in my court. So you've got two constitutional rights. You can have you have the constitutional right to be represented by an attorney, and if you wanted to have an attorney at public expense and qualified, to have that. You also do have the right under our Constitution to represent yourself. Obviously, you can't do both things at the same time. So do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law, before I accept that waiver, to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a $100 to $500 term. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on, I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on, well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? Is that okay?
Sure.
Okay. So one step at a time, I need to establish that you're exercising your constitutional right to represent yourself validly. So for me to do that, somebody might decide they want to do that and they really don't understand what's at stake. So I have to establish on the record that you do understand what's at stake.
Well, I think you have to establish on the record first that you can have jurisdiction. That's been questioned. It was questioned in the preliminary hearing. It was never addressed.
I'll address that today.
Well, it has to be addressed before anything can move forward, obviously.
Okay, so you want me to explain to you why I have jurisdiction?
Yes.
Okay, let's do that.
Which jurisdiction it's under?
Sure. Okay. This court has subject matter jurisdiction over crimes punishable by more than a year as the court of general jurisdiction under the Michigan Constitution of 1963. The people voted to ratify that Constitution. That is the underlying law of our sovereign state of Michigan.
Okay, so is that a jurisdiction under criminal? Or is it military?
Yeah, it's a criminal charge against you, and I have jurisdiction over that.
Okay, so the Constitution of the United States only grants you two criminal jurisdictions. One's common law, and one is military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Which of these two criminal jurisdictions is that?
You're not in federal court. It's not a federal crime you've been charged with. You've been charged with violating the law of the state of Michigan. And hey, what's going on over there? What are you doing, sir?
I'm trying to make sure that this is going live. It's not happening. There's something messed up with your film and I'm trying to straighten it out. I was just checking to see if it was recording or not.
Sit down, sit down. You're disrupting my courtroom.
Sorry, sir.
It's live. Any more disruptions, I'm gonna ask you to leave.
So common law,
McLeod, you're in a state court. You're charged with violating a law of the state of Michigan.
is that a statutory jurisdiction? What is it?
Yeah, it's a statute.
Okay,
And this court is duly authorized under Article 6 of the Michigan Constitution. So that's my jurisdiction. So now I need to make sure that you're establishing your right to represent yourself. So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine.
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to tell you to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General
The
jurisdiction.
people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. The legislative power is exercised by the House of Representatives and the state Senate. They have passed statutes that the governor has signed. The prosecutor's office is alleging that you have violated those statutes. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney withdrew. Oops.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing. Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I challenge subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
doesn't
jurisdiction.
exist under the Constitution.
Your objection is noted. Okay. So Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod,
the
stop.
court can be,
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
I've challenged this court's jurisdiction. You haven't established it yet. You said you got a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
McLeod,
statutes.
I have
act
other
as
matters.
clerk
Mr.
of some
McLeod.
involved agency. What's that?
You know, I understand you want to object to things, and you're going to be allowed to object to things, okay?
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
Your
and then
Honor,
we'll do it.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws, I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying it enough to where I can comprehend it, as you say.
you don't comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal.
There's no
it to the
such thing
Michigan
as
Court
a
of Appeals.
statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question or I'm going to hold you summarily in contempt. And the court officer will bring you to a jail cell and we'll talk about it tomorrow. You understand that?
So.
Mr. McLeod,
Contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? God's sake. Protecting my rights is what This isn't true. You guys are
Follow unconstitutional orders.
following law orders. It's not constitutional at all.
Mr. McLeod's in contempt, he's sentenced to 1 day in Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And we'll call the case of People of the State of Michigan versus Trevor McLoud. It's file 23-6748FH. How do you want to come up to the table, please?
All rights reserved.
Very good. Mr. McLeod, we were here last time and tried to conduct the arraignment. And you ended up being held in contempt. And so we're continuing the arraignment to today's date. So let's try again. All right, so Mr. McLeod, I've got to obey the dictates of the Michigan Supreme Court. And they make me go through certain things.
Sure.
You're here without a lawyer. So I need to obey the Supreme Court and establish certain things so that I can make sure that you can represent yourself. So you've got the right to represent yourself or to have an attorney represent you. You can't do both at the same time. So I need to establish which one you're choosing. So to do that, I have to first advise you of the maximum charges that you face. Count one is a charge of resisting obstructing a conservation officer with a habitual second notice. It's a felony punishable by up to 3 years and or $1,000 fine. Count two is operating a motorboat while intoxicated. That's a misdemeanor, punishable by up to 93 days and or $100 to $500 fine and or 45 days of community service, suspending the privilege to operate a vessel, cost of prosecution, or emergency response. Mr. McLeod, do you understand the maximum possible sentences for those charges?
Can I say something for the record?
No. I'm asking you a question. Do you understand the maximum punishments that you face?
Like, I don't accept those charges. I've got a treaty right here that says I wasn't doing anything wrong.
That's for later. All right, Mr. McLeod, you apparently want to do this the hard way again. I'm just asking you if you comprehend the maximum penalty that they're charging.
I
you.
comprehend.
Okay. So, do you understand that you have the right to an attorney, either hired of your own choosing or provided at public expense? Do you understand that right?
I comprehend.
Okay. Do you wish to have an attorney represent you, or do you wish to represent yourself?
I'm presenting myself. I'm here by special visitation as opposed to general appearance or lack of subject matter jurisdiction because of 1836 Treaty of Washington, which was further codified in 2017 consent decree, states that my vote is not legally registered, which makes this unlawful investigation fruit of the poisonous tree.
Okay, so you wish to represent yourself in this matter.
I'm presenting myself.
Okay. And has anybody promised you anything or threatened you in any way to get you to waive your right to an attorney, or are you doing that of your own free choice?
It's not a free choice, it's under duress, but I'm here to so.
Oh, you mean that you're not choosing to be here because of the charges? I just mean, so nobody's like making you give up your right to an attorney. Well, I said you got the right to an attorney. You don't want to have an attorney. Is that your choice, or is somebody like pressuring you to not have a lawyer?
Who's pressuring you to be here?
That's not what I asked.
Okay, well,
Is anybody pressuring you to give up your right to have a lawyer?
no.
Okay. See, I'm not asking you trick questions. I promise you, Mr. Mayor. These are not trick questions. All right. So I'm also required to make sure that you are doing this with open eyes, meaning that you understand the risks of self-representation. So as you found out last time, this court has procedures that this court will follow. And when people refuse to follow them, there will be consequences for that. If you're representing yourself, you're going to be held to those same procedures just like a lawyer would. Do you understand that? Do you comprehend that?
I comprehend that this court does what it wants and violated the process when they arrested me, so we lost subject matter jurisdiction. This whole thing is a shame.
That's not what I asked you.
Okay.
Do you comprehend that I'm going to hold you to the same standards of procedures that I would to an attorney?
I don't think that's how it should be done. I think there's case law that says that when people present themselves, they have different standards.
Well, they don't. I mean, I try to work with them as I am with you. I can promise you I don't have these types of conversations with lawyers at the arraignment because they know what they're doing. So I'm trying to give you a little bit more leeway. But you have to follow the procedures as they are dictated by the Supreme Court and the court rules, and as I say them to be. Not what you think they ought to be, but what I say they are. Do you understand that?
I don't understand. I comprehend it.
Okay. All right. Now, because of that, attorneys have had to, be licensed to understand those rules and have degree from a law school where they've spent 3 years studying those rules. And so there may be things that they're aware of that you may not be. So when somebody represents themselves, there may be a defense to the charge where a lawyer might recognize that defense and present it, and somebody representing themselves might miss that defense. So when you represent yourself, you take the risk of that happening. Do you comprehend that? All right. So let me give you an example of that. So about 2 years ago, I had somebody in my court in my other county, similar to your beliefs about the law. And this defendant was raising similar claims as you're seeking to raise here. And they didn't prevail because courts don't agree with those claims. And the person became so disruptive, I withdrew their permission to represent themselves. And I appointed an attorney for that person against their will. The attorney recognized that there was a defense to the charge filed a motion and I dismissed the case on the attorney's motion, the person representing themselves would have never recognized or did not recognize that defense. So do you understand, when you represent yourself and give up the right to be represented by a trained attorney, you're taking a risk that there may be defenses that you might miss.
I comprehend what you're saying,
Okay.
so we can just move forward from that term.
All right. So then the final thing that I have to decide is whether your self-representation will disrupt, unduly inconvenience, or burden the court and the administration of the court's business. If I'm judging it just on last time's appearance, I would say, well, yeah, you're going to be disruptive, so I'm not going to let you represent yourself. Today, you've been tempted to go down that road, it seems to me, but you've trained yourself. So I'll at this point find that you representing yourself is not going to unduly disrupt, inconvenience, or burden the court's business. But you should understand, Mr. McLoud, that changes when you decide that you're going to run this court, which you do not. Then I will withdraw your authority to represent yourself, and I'll appoint an attorney to speak for you, and you won't be allowed to speak. But as long as you're going to, follow the proper procedures, at this point, I'll let you represent yourself. All right. So I will find that Mr. McLoud is unequivocally waiving his right to counsel. He's made that right knowingly, intelligently, and voluntarily, and he's aware of the disadvantages of self-representation. And at this point, I'm finding that his self-representation will not be disrupted to the court's business. All right. There. Now, Mr. McLoud, I have to arraign you on the charge itself. Have you been given a copy of the document called information felony, the charging document that contains the charges against you? Okay. You would have the right to have me read that document in full on the record. Do you wish me to do that, or do you want to waive the reading of the information?
I guess it's for procedure.
Okay. So count one charges you with resisting, obstructing conservation officers, and it alleges that you did knowingly or willfully obstruct, resist, oppose, assault, beat, or wound C.O. Layston Feltz, an officer appointed by the Director of the Department of Natural Resources when said person was making an arrest or search contrary to Michigan law. That's normally a high court misdemeanor punishable by 2 years and or $1,000 fine. There is a habitual offender second notice indicating that the court should take notice that you were previously convicted of a felony or an attempt to commit a felony in that on or about February 12th, 1996. You were convicted of the offense of larceny from a motor vehicle, violation of Michigan law, in the 53rd Circuit Court for Sheboygan County. Therefore, that increases the maximum penalty to 1.5 times, meaning that resisting obstructing charge is punishable by a maximum of 3 years and or $1,000. Count two, marine safety operating while intoxicated, alleges that you did operate a motorboat on the waters of the state while you were under the influence of alcoholic liquor contrary to Michigan law. That's a misdemeanor punishable by 93 days and or a $100 to $500 fine and or 45 days community service. Court to suspend privilege to operate vessel 1 year to indefinite, and the court can assess the cost of prosecution or emergency response. All right. Mr. McLeod, how do you wish to plead to those charges? You can either plead guilty, not guilty, or you can stand.
I don't plan on pleading because I have a decree right here that says I wasn't violating any laws. Stop it from lawful, which makes everything after approved in court history. So
Well,
that's for evidence. Copy of my tribal card, a copy of the excerpt from the 2017 consent decree.
Well, that would be like a motion to dismiss later on, which you could file. In fact, you had filed a couple motions to be heard today, and then you withdrew them. If you file motions and want them heard, I will hear them. I'll hear your arguments, and I'll rule on them on the merits and the law and the facts. But you can't skip the entering of a plea and go right to a motion. So I first have to enter a plea, either guilty, not guilty, or you can stand mute and refuse to enter a plea. Am I understanding that you are refusing to enter a plea? Which is fine. That's not a violation of court procedure. It's one of your options. You have three options right now: to enter a plea of guilty to the charges, to enter a plea of not guilty to the charges, or to decline to enter a plea to the charges. Which of those three options?
I decline that.
Okay, that's fine. That's your right to do so. So Mr. McLeod is standing mute as to the charges. The court will enter a not guilty plea on his
I
behalf.
object to that, Your Honor.
Well, I'm sure you don't want me to enter a guilty plea, so I have
Well, you can't.
to enter one or the other.
Not guilty on behalf of you practicing law on the bench. So are you finding it because of determination that I'm not guilty?
I do not have to subject myself to your cross-examination, Mr. McLeod. That's not how this works. All right, so I'm going to enter a plea of not guilty on your behalf. Mr. Juliet, are the people requesting a referral to the forensic center?
No, Your Honor.
I don't see any indication that Mr. McLeod is incompetent to stand trial, so I won't make such a referral on a court's own initiative. All right, so Mr. McLeod, the other thing I have to do today is kind of pick a day for us to come back, hear any motions that you may file and schedule, or the prosecutor may file and schedule, or to see if there's a resolution of the case, or to schedule a trial. And we call that a docket call, because we're calling the case to the docket. So I've got to pick a docket call date. Usually do that about a month out. So I could have you come back Tuesday, February 6th at 9 a.m. Juliet, what would be the estimated length of trial if the case went to trial?
1 day.
All right, Mr. Juliet, anything further from the people?
I received an email yesterday from Mr. McLeod. It appears to be a dispositive motion to, I would say, suppress the evidence. I know he filed a motion based on summary disposition a while back that was withdrawn. I would just request that if he wants to move forward with that motion to suppress, just give us a copy of the written motion. Perhaps the court can hear it on the 6th. I would just ask 7 days to respond to it.
All right. So, Mr. McLeod, I've done everything I need to do today in terms of determining whether you can represent yourself, advising you the charges, entering a plea, and scheduling our next court date. You can feel free to file any motions or objections that you want to have heard to be heard on that date. I can't rule on things orally on that regard. It sounded like today you wanted to tell me some things about a treaty and things like that. You might be right. I don't know. But I'd have to review your written materials. I'd have to review your argument. I'd have to hear from both sides and then make a decision on that. We can do that on the 6th if you file the motion and notice it up to be heard that day. Is there anything further for purposes of arraignment today?
I'd like to have the motions heard earlier than that. And I'd like to be relieved of my bond restrictions, which are quite invasive, honestly.
Well, you filed a motion to review those and then you withdrew your motion.
Because I want to do it separately.
I mean, well, I guess I could make one exception to that the court rule does allow bonds to be reviewed at any time. So I do allow oral motions to review bond. So if you want to talk about your bond conditions right now, I'll certainly do that.
I think they're very restrictive. I think they're a violation of due process. I think that they're unnecessary to prove that I'm going to show up or that I'm not dangerous to the public.
And review what those conditions are, because I didn't set them. Those are set by the district court, so let me review here. Which conditions is it that you are thinking are unduly restricted?
They're having you call every morning to take a drug test.
Is that the only condition you're seeking to have removed?
It's really the only one that, well, not being able to leave the state is kind of silly too. I travel for work.
All right, Mr. Juliet, Mr. McLeod is objecting to the bond conditions of calling the bond line for testing every day and not leaving the state of Michigan. Any response?
If he works out of state, I have no objection to that. We're striking that from the bond condition. As far as the bond line, I mean, this is an alcohol related offense. It has been a while. I mean, there's been no bond violations, so I don't have any objection to the board striking either.
Okay, now the initial conditions downstairs did say except travel for work purposes. Or, I mean, looking at this charge, I've got a misdemeanor charge. I've got a fairly low severity felony charge. So, I mean, if Mr. McLeod, if you didn't show up for court, that would be a problem. But if you wanted to, you know, go to another state for work or frankly for any other reason, I'm not sure why I would care about that. I don't think that would. I don't think this is the kind of case where you would pose a flight risk. So I am going to amend the bond conditions to remove the bond line requirement. And remove the restriction on out-of-state travel. If this were a drunk driving charge with a motor vehicle, I don't think I'd remove that because I think I'd still want to have you do testing, but I'm really not too worried. You're going to be operating a motorboat right now anyway. So I'll grant that request, Mr. McLeod, and remove those two bond conditions. The court will enter an order so that you don't have to present one to us, effectuating those changes. Anything further for today, Mr. McLeod? Okay, we'll see you on the 6th. If you do want your motions heard on an earlier date, you can contact the assignment clerk and see if there's a date we can get you in soon. All right, have a good day. All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we're providing public access both in the courtroom and also online. And first up, we've got the case of People of the State of Michigan versus Trevor McLoud, file 23-6748FH. Mr. McLeod, good morning. Sir, would you step behind the bar, please?
He's by counsel.
He's not a licensed attorney.
Could we have
I demand my right to counsel.
Sir, step behind the bar or you're going to be taken into custody. You're not an attorney, so gather your things. You can step behind the bar. I'll explain this in a minute.
the papers?
So, Mr. McLeod, I first have to establish then you've told me before that you wanted to represent yourself. Are you changing your mind on that matter?
I'm bringing in my own counsel from the tribe, yes.
Is he an attorney licensed in the state of Michigan?
He doesn't have to be.
Yes, he does to practice in this court. So you're not wanting to represent yourself then? Am I hearing that correct? You want an attorney?
I have a right to counsel.
Yes, you do.
Doesn't have to be a licensed attorney.
Yes.
No, it doesn't.
In a courtroom, who do you think gets to decide that question? You or me? So me. And so you may be represented by an attorney, but it has to be a member of the bar of the state of Michigan. Now, I can tell you, I read your motion and Mr. Belkey's purported appearance, which is not authorized. And it seems to me that perhaps you want him just to explain some things to the court about the consent decree.
That's correct.
Now, for that purpose, in your motion, you may call him as an expert witness on that question, and he can offer testimony on your behalf as a witness.
Okay.
But I can't allow him to make arguments on your behalf or represent you in the case.
Well, that's why we put it in for limited.
Okay, so you just want him to offer some testimony about that stuff?
Sure.
Okay, so we can do it that way, and he can testify as a witness. There's no problem with that. Assuming that he meets the requirements for a witness and, you know, have to follow the rules of evidence and all that.
Sure.
All right. So with that in mind, then, I need to confirm, are you still desiring to represent yourself?
Yes.
Yes, you are. Okay. All right. So we are here on your motion to suppress. There is in the court file a preliminary examination transcript, so I did have an opportunity to review that, and I'll take judicial notice of those proceedings. So then I suppose we can take supplemental proofs. So Mr. McLeod, I guess, at the preliminary examination, the conservation officer testified about his actions and observations that day. Did you wish to have him offer further testimony about that, or do you want me to just rely on the transcript of the preliminary exam?
I think we have to rely on the transcript.
Okay, Mr. Juliet, do you wish to supplement that in any way, or?
Just very briefly, and I believe he's on Zoom for testimony, if that's okay.
Okay, any objection to that, Mr. McLeod? To,
Yeah, I object.
What's that?
I object.
What's the basis for the objection?
That his testimonies, I've already got proof of perjury here.
Well, that doesn't tell me why he shouldn't be allowed to offer some additional testimony.
Because it's not valid. You can't trust it. He's already lying.
He's what?
He's lying.
Well, again, that's a different problem. I mean, if a witness testifies falsely under oath, that's, you know, serious problems for the witness. But the prosecutor's saying they want to offer some additional testimony by the correction officer. So I'll allow that, and then you can cross-examine them, and then you can present witnesses in your own defense. All right, let's see here. Good morning, sir. Can you tell me your name?
Alexander Bourgeois.
Mr. Bourgeois, would you please raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Go ahead, Mr. Juliet.
Officer, can you hear me all right?
Yes, sir.
Can you state your full name and spell your last name, please?
Alexander Bourgeois, Bourgeois.
Thank you. Where do you work?
I currently work for the Michigan DNR in the law enforcement division.
And how long have you been working there?
Since August of 2022.
Were you working on September 4th of 2023?
I was.
And are you familiar with the defendant in this case, Mr. McLeod?
Yes, sir.
Did you have contact with him that day?
I did.
And what was the reason for the contact?
We originally made contact with him because he had expired boat registration on his vessel. Upon making contact with him, it led to the arrest of him for boating under the influence.
Okay. Was there anything else that drew your attention to the defendant?
Yes, we originally made contact with him at the boat launch.
Hang on. There was an objection. What's your objection to that question?
They're trying to add testimony to the statements in the original testimony. That's not stated.
Well, that's
Trying to change the story.
okay. Well, they are allowed to present, you know, testimony here today, and I agree that's exactly what they're trying to do. They're trying to supplement the record and give me some additional information that wasn't in the attachments or in the prior transcript. That is permissible, just like you're going to be able to offer further testimony from what you gave in the district court. So I'll take all those things into account. So that objection's overruled. Go ahead.
So I'll just repeat myself, officer. Was there anything else that drew your attention to the defendant?
Yes, when the defendant docked at the dock along the river, when he got off the boat, myself and the other conservation officers, we realized that he had difficulty getting off the boat, that he had to hold the post to get off of it. Once he had gotten off of the boat and he walked towards the bathroom, he stumbled and swayed up the dock and ramp, and stumbled and swayed on his way back. That's when I made contact with him about the boat registration. And once I asked for the registration for the vessel, which obviously would be inside of it. He struggled to put his sandals back on longer than a normal person would. It took him about 10 seconds to put on a simple sandal. And then once he got into the boat, I noticed that he had lack of fine motor skills that would be common with somebody that's under the influence. I noticed that he had slurred speech. And then he also, I could tell that he showed just general signs of someone that might not be completely sober.
Okay. As part of your training as a conservation officer, do you receive any training in OWI related boating incidents, I guess?
Yes, we're trained in both normal motor vehicle, and then I myself am trained in BOI.
Okay. And before you, I guess, approached, can you explain the timeline of events? Did you notice any signs of intoxication before you made contact with the defendant?
I object.
Hang on, there's an objection. What's the objection about? What's that? I'll sustain that. Maybe you can ask him, when did you notice any?
Officer, when did you notice the signs of intoxication?
I noticed it as soon as he tried to get off the vessel, when he was stumbling and was having difficulty getting off of it. The water wasn't rough or anything that would cause any type of equilibrium imbalance. It was a calm, flat river, so the defense of that wouldn't be valid in my opinion. So when he's stumbling to get off of the boat and then stumbling up the dock, it would show that he would be impaired on something rather than from the water.
Where were you when you noticed this?
5 feet away from on the other side of the dock. I had clear vision of it all the way up the ramp too.
And did you approach him after you noticed these signs of intoxication?
Yes, sir.
Okay. Did he, when you made contact with him, did he inform you that he was a tribe of a member of a Native American tribe?
No, sir. Nor did he advise me that he was in the.
Hang on. There was an objection, and Mr. McLeod, it might help a little bit if you would state your objections a little more loudly, so that the witness who's testifying remotely can hear that. The question was, did he tell you that he was a member of a tribe?
Yeah.
And there was an objection. The reason
He's leading the witness. He's leading the question.
Well, I think that I'll overrule that. That doesn't suggest what the answer is. He's saying, did he tell you? The answer could be yes, it could be no. So that'll be overruled. Go ahead, Officer Bourgeois. Did Mr. McLeod inform you of his membership in any Native American tribe or band?
No, sir. He didn't advise me that he was tribal, nor did I see him in the act of fishing. And either way, as a conservation officer, I have the right to make contact with him. And upon that contact, I would have observed his signs of intoxication. So
right, I'm going to strike hang on. You've done way more than answer my question. I'm going to strike everything you said after no.
Okay.
All right, just answer the question. Thank you. All right, go ahead.
So can I just repeat?
Yeah. No, you don't have to. I mean, it's asked and answered. I heard the answer is no. We didn't tell him. Okay. So go ahead.
Did you see any evidence of fishing related activity?
No, sir.
I have no other questions.
All right, Mr. McLeod, do you have questions for Officer Bourgeois?
Yes.
Go ahead.
Have you ever seen him walk before?
I'm sorry. Can you repeat? I'm sorry to hear you.
Have you ever seen me walk?
Ever seen you walk?
Yeah.
No, sir. The first time I made contact, I've ever seen you in person was on that day.
Okay. Are you aware that I had a double hip replacement?
No, sir.
Okay. So you made a determination that you, what's your basic comparison of how I walk and what my gait might look like?
I would base it off of a normal human being. I mean, we see people walk every single day. So if someone's swaying, stumbling up a ramp, walking side to side along the ramp, struggling to use fine motor skills just to put their foot in a sandal, I would assume that would show signs of intoxication.
Well, you never asked if I was disabled or previously disabled.
No, but that would have been part of my questions upon doing the test. I would have done a medical screening, which you refused to do.
So you state in your testimony that your partner fell on top of me.
Yes, sir. During the wrestling to get your hands behind your back, yes, he fell on top of you while you were resisting.
You also state in your testimony that your partner advised me to put my hands behind my back, but I refused. Is that correct?
You did. Yes, sir. Yep.
You also state in your testimony that your partner was able to actually just cuff me without me complying. How did that go down?
I'm sorry, I couldn't hear after the cuff part. What was that?
Your partner was able, you state in your testimony that your partner was able to actually just cuff me without me complying. How did that happen? Explain that to me.
He grabbed one arm, cuffed it, and then you refused to comply. You continued to keep your other arm away from him. You actually were laying on it with it underneath your chest, and he ended up able to roll you over, grab your arm, and then pull behind your back and cuff you without you ever complying.
You also state in your testimony that you advised me that I was under arrest for boating under the influence. Is that correct?
Yes, sir.
When did you advise me of that?
Before we even entered your vessel, we told you to step out, that you'd be under arrest for boating under the influence, and you stated no, which would be further resistance because it was a lawful order.
No further questions.
Are you any redirect?
No.
Right. Thank you, officer. So do you wish the officer to, well, we should probably remove him from the meetings in case there's a trial. All right. So Officer Bourgeois, thank you for your testimony here today and your excuse.
Thank you, sir.
Any additional proofs from the people?
No, thank you.
Okay, Mr. McLeod, do you wish to present any witnesses in support of your motion to suppress?
No. Oh, yes, I was like Mr. Belkey.
Okay, Mr. Belfi, you want to come on up to the witness stand, sir?
And for the record, I think it should be Dr. Belkey.
Oh, okay, I'm sorry.
Okay.
That's fine. I forgot. Dr. Belfi, please raise your right hand for me. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? So help you
I
God?
certainly do.
Okay, you can be seated. And can you state your name for the record and spell your last name for us, please?
My name is Dr. Phil Belfi, and the spelling is Bellfy.
Okay. All right, thank you, Dr. Belfi. Mr. McLeod, go ahead with any questions you have.
Mr. Belkey, could you explain to the prosecutor who holds jurisdiction in
Could you give me that one piece of paper?
Calls for a legal conclusion.
Hang on, there's an objection here. So, Mr. McLeod, I mean, you're doing fine in representing yourself. I guess I'll sustain that objection. How you need to proceed with an expert witness first is ask Dr. Belfi some questions about his education background in the area, and then the prosecutor will have a chance to do some follow-up questions if they see fit. And then you would ask the court to recognize Dr. Belfi as an expert in a particular area. And then if that's accomplished, then you can ask him his opinions in that area. So why don't you go ahead and just start and ask him a bit about his background.
Mr. Belfi, what is your area of expertise?
I have a PhD in American Indian Studies. It's not called that, but that's what it is. And I am professor of American Indian Studies for Michigan State University. I'm retired now, but I'm professor emeritus of American Indian Studies. And I've also been qualified and admitted to practice tribal law in the Sault Ste. Marie Tribal Court. And my entire academic career has been involved with treaty issues and court cases and those types of things. So I don't want to be real vain about it, but I would consider myself to be an expert, quite frankly.
Hey, Mr. Belfi, can you explain to me who holds jurisdiction over the interpretation of the 2000?
Objection has been
Yeah, I
qualified.
haven't even heard the question. So go
Can
ahead
you
and ask.
explain to me who holds jurisdiction over the interpretation of the 2007 Inland Consent Decree?
Okay, and now there's an objection.
He hasn't been qualified as an expert.
Okay, so maybe ask, well, I guess let me just handle it this way. Dr. Belfi, can you tell us, there's been a question about the 2007 consent decree. Do you know what that is?
I most certainly do, yes.
Can you tell me what that is?
The state of Michigan and the federal government had a court case called US v. Michigan that dealt with fishing rights. And Great Lakes commercial fishing, more or less. And there was always a question about the inland rights that was not addressed during that court case. And the court case took a long time, et cetera, et cetera. But when Mike Cox was the Attorney General of the state of Michigan, I can't remember what year that was.
Hang on, but you're kind of telling me your thoughts about it. I'm
No,
asking
not
just in
that.
more general. So this is a consent decree between the state of Michigan government?
The consent decree is three parties, all the tribes in the 1836 treaty area, the state of Michigan, and the federal government. They all came together to sign that consent decree in 2007.
Okay, and what's your familiarity with that decree? Have you read it, studied it? Have you taught it as a professor? What's your familiarity with that consent decree?
All of the above.
Okay.
Yes. And it became that and other issues, of course, became part of my dissertation. So I've studied all of that very deeply.
All right, go ahead, Mr. McLeod.
I guess, is he qualified?
I'll stipulate to his qualifications.
Okay, in what specific area then? Well, I guess the court would recognize Dr. Belfi as an expert witness in the area of Native American studies, to offer his opinion in that area as pertaining to the 2007 consent decree. Okay, so go ahead, Mr. McLeod.
Could you explain to the court who holds the sole jurisdiction over the interpretation of 2000 consent decree?
Okay, and I'm taking it out of my memory. You got the piece of paper there. It's the first area of the consent decree talks about jurisdiction. And then there's 3 paragraphs there, and paragraph 1.2 lays out exactly who has jurisdiction over the interpretation, etc., of that consent decree. Anything that has to do with the consent decree, when it's being questioned, the only people that have control over that is the federal court in Grand Rapids. They're the people who did the original fishing rights case, and they also did the consent decree and negotiated all that process. It took many years to do all that. And so they retain jurisdiction over everything that deals with that consent decree. So if there's some mention in the decree about you can not have, I don't know the number of it, but you don't need to have your boat registered if you have fishing gear on the boat. That's in the consent decree. And if there's an interpretation that needs to be done on that question, then it has to go to the federal court. They have the jurisdiction. And I don't want to say anything disrespectful about the prosecuting attorney, but that's not part of his role. That is it's a federal case. It's a federal consent decree. The state of Michigan agreed to it. In other words, they agreed that the federal court has jurisdiction over the interpretation. And everything that's in that decree is under the federal jurisdiction. So I don't, it's not my position, of course, to say whether or not Mr. Juliet can
Sure. So, Mr. McLeod, are you, okay, so this is the cover page and page 7 of the consent decree. We staple this and mark this as a proposed exhibit for defense 1. Mr. Juliet, have you had a chance to see that?
If I could just briefly take a look at it.
Yeah, defense 1. And I think Mr. McLeod is offering that exhibit into evidence. Any objection?
No.
All right, exhibit 1 is admitted. And it's the cover page of the consent decree. And page 7 of it, which does have jurisdictional paragraphs indicating that the court shall retain jurisdiction over the parties and subject matter of this action to enforce the decree to resolve disputes arising under it. Okay, continue, Mr. McLeod. Okay, any cross-examination?
Yes, you said you've taught taught classes on the consent decree before.
I did not teach a class on the consent decree. I mean, there's no such thing. But I did, half of my load at Michigan State University was involved with Native issues. They let me teach half of my load in Native American Studies courses. And every course that I teach in Native Studies, the beginning of every course is the treaties and the discussion about the treaties and the treaty rights. So the fishing rights case and the inland consent decree, they're an integral part of everything that I do.
Okay. I think you've read the consent decree.
I've read this consent decree several times.
Okay.
I have to be honest though, when it talks about how many fish you can take out of a particular lake, I don't have that in my mind. But all of the preliminary stuff, all the arguments that deal with individual rights under the consent decree, I know them very well.
Okay. So you know that a tribal member who is subject to certain requirements does not have to present, he must possess evidence of fishing or hunting or trapping gear to shield himself from that registration requirement, correct?
The language of it, and I don't remember the number, and I don't know if Trevor might have a copy of the page.
24.4.
24.5? It says that the boat, it doesn't have to be like putting the pole in the water, but there must be fishing gear on the boat.
Okay. And so they just simply have to possess it.
They simply have to possess it, yes.
Okay.
That's what the consent, that's the language of it. Then I should give a little bit of an aside. As part of my research, I talked to people who negotiated the consent decree. It took them 4 years to sit on the consent decree. And the reason it took 4 years to do that is because literally, and this is how it was told to me, every word had to be discussed. Do we put the word shall or do we put the word may? And that might take 2 weeks to figure out, is that word we're going to use? Which one are we going to use? What's the consequences of this? Because this is an important issue. It's a treaty thing, so it's at the top of the list. Treaties are the supreme law of the land. So when it came to the word possess, I'm going to assume that that's what they meant. You have to have a fishing pole in your boat, a net, or whatever it is that you're going to use for your fishing. It's got to be in the boat someplace.
Okay, thank you. Your Honor, I have no other questions.
Do you have any additional questions for Dr. Bell?
I don't.
Hey, Dr. Bell, yeah, I have a couple. So you say that you serve as a tribal advocate in Sioux tribal courts, correct?
I no longer serve there because they revoked my permission, which is, quite frankly, is still under dispute.
Okay, but you have in the past.
I have in the past, I have the documents.
Do you have familiarity with how the tribes that are parties to the consent decree have implemented the provisions about boat and vehicle and snowmobile registration? In other words, my question is, do the tribes issue their own registration for any of these vessels, or
Not that I'm aware of.
so in your, have you represented in tribal courts,
I'm sorry,
object to what?
to trying to interpret the consent decree.
Oh, I'm not trying to interpret the consent decree. I'm asking Dr. Belfi his opinion about just, the court is allowed to ask questions. So Dr. Belfi, do the tribes don't issue registration for vessels?
Not that I'm aware of, no. But they do issue, if you're a tribal member like Trevor, they issue you cards
Yes.
that show that you're a tribal member, you have the right to do whatever it is that you get a permit for.
All right. Do you have any knowledge about if non-tribal law enforcement sees a vessel with no registration or expired registration, do you have any experience or knowledge based on your studies of the consent decree about how that's handled, how law enforcement is supposed to recognize if something is a tribal vessel not subject to it, or a non-tribal vessel subject to it? And if you don't know, that's fine. That's a question for me to ask the parties' arguments. But if you have any knowledge about that,
I do have some knowledge in that, yes. If the non-tribal law enforcement officer can draw, the instant that person or anybody discovers that the person is a tribal member, that's when the jurisdiction ends. According to everything that I've read and everything that I've learned, when it's cross-deputization arguments. If, for example, Trevor was taken downtown and taken to this building, I suppose, people who were in the building, presumably, knew that he was a tribal member. It was at that moment that the jurisdiction transfers from this particular court to the tribal court. And that's what the cross-deputization is all about.
all right, thank you. Any further questions as a question, Mr. McLeod?
No further questions.
Any further questions as a result of the court's question? Okay. Thank you, Dr. Belfi. Mr. McLeod, do you have any additional witnesses you wish to present or evidence?
No, thanks.
All right, anything else first, Mr. Juliet?
No, thank you.
Mr. McLeod, it's your motion to dismiss. I have reviewed your motion and your reply to the prosecutor's response, but now you also have an opportunity to make any argument you want in support of your motion.
I'd like to submit this. I was told to play a disc for the court today. So I brought it with me.
What is that?
It's a video of me being on the boat and the officer stepping onto the boat and me putting my hands behind the back.
Is there body cam footage?
No, it's a Snapchat that one of my guests filmed.
Okay, has the prosecutor had an opportunity to review that?
Yes, they've had it since September.
Okay. Any objection to that being admitted?
No, that's fine.
Okay, so if we can mark that as defense exhibit 2. Do you know how long that video is?
10 seconds. 7 seconds.
7 seconds. So 2 is committed. Well, what we could do is we could take a 5-minute recess for me to,
Well, can I submit this along with it so you can take this into recess with you?
well, what is that?
This is part of Officer Bourgeois' testimony from my preliminary hearing.
Well, I have the transcript. You can just tell me what page.
It's page 16 and it's line 7, 8, 7, 8. And, well, there's other lines in there, but that's the main one I want you to look at.
Okay,
Line 7, 8.
page 16, starting at line 7, the court can take judicial notice of the records in the court file, including the preliminary examination. So you want me to kind of view the video in context for this testimony and compare the two?
Yes.
Okay, so what we could do is I can take a 5-minute recess. I can't play it on this computer, but I'll go and watch it and come back in 5 minutes. Thank you. All right, thank you. I've had a chance to watch Defendant's Exhibit 2 and compare it to the testimony of the officer on page 16 of the preliminary examination transcript. Mr. McLeod, go ahead and make any additional arguments you want in support of your motion to suppress.
Well, I think that we need to impeach that whole officer's testimony because he's clearly lying from the facts of what happened that day. And he's lying under oath, which is perjury. So that's my motion is to impeach everything that he said.
All right, thank you. Mr. Juliet?
I guess I would just first take note that this is a what I view as a motion to suppress based on a unconstitutional stop. The case on point is Terry versus Ohio, which states that a temporary investigative detention may be based on reasonable suspicion when an officer observes unusual conduct which leads the officer to reasonably believe, in light of his experience, that criminal activity may be afoot. The officer testified that he was on patrol on the Sheboygan River, that he observed the defendant's boat registration to be out of date. Upon further observation, he observed what he testified to be signs of intoxication. I think that alone satisfies the reasonable suspicion test. As to
I object, and the reason why is because I'm showing that this officer, his testimony can't be trusted.
Okay.
So how can we trust the fact that he's saying I observed this or I observed that when he's lying?
Okay, and that's more in the form of a rebuttal argument than an objection. So Mr. Juliet can make his argument, and then you, as the moving party, you'll have a chance to make a rebuttal argument. Continue.
So just as to the inland consent decree, I did misquote in my original response that the defendant must present evidence. I did submit a amended response. He only needs to possess that evidence.
Change the word.
When the officer made contact with the defendant, he had no idea he was Native American. He didn't see any fishing gear or anything like that. So I don't think that the inland consent decree really shields the defendant in this case.
Well, can I ask you, so do you concede then, so let's say they make contact with them and they learn that he's a member of the, are you a member of the Sioux tribe? He's a member of the Sioux tribe. They can't write him a ticket for the unexpired or for the expired registration, correct?
Well, I can answer that 2 ways. Based on my understanding is that he would be shielded from the civil infraction ticket if there's possession of some sort of fishing gear or something like that. But based on Dr. Belfie's testimony, I think that unless the DNR officer has some knowledge that he's a member of a Native American tribe, I don't think that can be imputed to the officer to just automatically know that he's a member.
Okay. Can I ask you, have you seen this 6-second video clip?
Yep. Yes, I have.
What am I to make of the fact that that appears to depict something different from what is described by the officer's testimony at page 16?
Well, I don't think it describes that at all. I mean, that's a video that they're on the dock. The RO happened in the boat. So
No, this is in the boat, and the video shows Mr. McLeod standing there talking to the officers, engaged in some conversation with them. The officer steps aboard, stands behind him, and grabs Mr. McLeod's hands, and both hands are being brought behind his back, certainly by the officer, but with no apparent resistance from Mr. McLeod.
okay. Well, to that, if the court's going to, I guess, ask that question, that's a question of fact, the right to resist an unlawful arrest at a jury or bench trial.
No, I'm saying I didn't see any resistance.
There's testimony that he did resist. I mean, the video is only a few seconds long.
Thank you. Mr. McLeod, any rebuttal argument?
Like Mr. Belfi testified, this document's not open to interpretation by anybody in this room. It has to go to the Western District of Michigan. And certainly not Mr. Juliet has any qualifications to make any interpretations on this document. Without some consent decree.
Thank you. Well, Mr. McLeod has filed a motion to suppress the evidence because of essentially an illegal stop or search or seizure. Some of his arguments sort of blend into a motion to quash for lack of evidence as well. In terms of the suppression, so there is evidence in the record now and testimony about this 2007 consent decree, and that Mr. McLeod is a member of a tribe that's a party to that consent decree that would shield him from prosecution for or from laws regarding registration of vessels. If he possesses evidence of fishing or whatnot. We're not here on an expired registration matter. If we were, Mr. McLeod may well have valid defenses to that. What we have is a non-tribal law enforcement officer sees a vessel underway on navigable waters and sees an expired registration date. So I think that gives the officer reasonable suspicion to make contact with the operator of that vessel. And that's consistent with Dr. Belfi's testimony as well, that they can make the contact, and then as soon as they know there's a issue, then, at some point, that their jurisdiction to enforce that, may divest. And I understand Mr. McLeod is saying, well, they never gave me an opportunity to tell them that because we're right in the middle of it, right from the initial contact. But be that as it may, I think the testimony, including from Dr. Belfi, is law enforcement, they don't know if something's a tribal vessel or not, whether it's operating under this consent decree or not. They see a vessel on the waters of Michigan with an expired registration. They're allowed to make contact with that person to find out what's going on. The officer did testify that even before making contact with Mr. McLeod, they observed what they thought to be evidence of impairment. So that's the initial contact is not a constitutional violation, nor is it a violation. It doesn't appear to be a violation of the consent decree either. It's the initial contact, and there's evidence of the impairment right there. So now they're beginning an investigation for impaired operation of a vessel.
Well, I object, Your Honor. I want you to take a look at the MCL, the Michigan compiled law that has to do with this OWI on a boat.
Oh yeah, that you're not
Section-
operating.
Yeah, it was docked.
And I've reviewed that argument that Mr. McLeod says he wasn't operating. And he's correct that he wasn't operating the vessel at the time they made contact with him. You're right.
Yeah, it was docked and tied off and shut off. Keys were on it.
Right. But they did, the testimony.
Well, I object to their testimony being valid. They're lying. I've got proof of it.
Well, I've heard the arguments. I let you make your arguments, and now I'm making my ruling. I lost my train of thought. That's right. So they at the time they make contact, Mr. McLeod was not then operating the vessel. But they did testify that they saw him observe that he's at the helm. It's under throttle because the flow of the river would mean that it would have to be under throttle to approach the dock in that direction. They saw him with his hand at the helm and at the throttle. So they observed him operating.
They observed me operating with a beer in my hand or drinking. And also,
I need to make my ruling. I need to make a record without this back and forth.
okay, but I want to make part of the record too, is that we were sitting at that dock drinking alcohol and beer before those guys pulled up to us. So there's no way they can determine.
Okay, well, that's a different issue. You know,
Okay.
doing this one at a time.
Okay.
So that they're allowed to, they observe him operating the vessel. They're allowed to make the initial contact because of an expired registration. As they're making that contact, they see evidence of some impairment and begin an impaired operation of a vessel investigation. That's all lawful. And so for that reason, the motion to suppress evidence for an unlawful stop or seizure is denied. And to the extent it's a motion to quash the information or dismiss because of lack of evidence of resisting or lack of evidence of operation, there's at least probable cause of that to support the bind over from the testimony. He's resisting the commands to leave the vessel. They do complete an investigation for the impairment. Now, Mr. McLeod certainly has some evidence to support his defenses, including the video that I watched that does, it's just a snippet of time, so that I can't dismiss the charges based on that video, Mr. McLeod, because it doesn't show me everything they have.
But it shows you the officer perjured himself.
Well, you're going to get to show that to a jury.
Sure.
Okay. And
so that's where we're going.
Yes. So I'm going to deny your motions to dismiss or suppress based on the law because the officers had a right to make contact, and they say that the evidence of impairment was evident on that initial contact. But these issues are all things that you can present at a jury trial. So do you wish to represent yourself at a jury trial, or do you want counsel for that?
I'm not going to make that decision right now.
Okay. Well, what we'll do is that's fine. We'll have you come back in a couple of weeks. And then at that point, if you want a jury trial, I'll give you a date. If you want an attorney, you can hire one. It's got to be,
I'm going to need some more time in a couple of weeks because I'm going to be appealing this decision, which I'm going to want, right?
Okay. That's fine. You did
I
that.
motion for time to file an interlocutory appeal.
That's fine. That would be, you'd have to file that to the Michigan Court of Appeals, and you certainly have that right. So what I'll do is I have these handwritten docket call orders. So they're scheduled for docket call. I'll write on here defendant's motion to suppress is denied for the reasons stated on the record. And your time frame to file that interlocutory appeal would flow from today's date. Then this will be the written order, and you can get a copy from the court. I'll have you come back on we can put it out a little bit. I could put it out to March 19th, and that way then if you have filed the interlocutory appeal by then we'll probably be talking about whether we want to stay the case or not. And if you've decided not to, then we can talk about whether you want a jury trial and whether you want to give you time to sort those things out. So we'll come back March 19th at 9 a.m. Anything further, Mr. McLeod, on today's records?
Well, I'd like to submit this page 16. Oh, actually, I'd like to submit all my exhibits from my motion to suppress into evidence for if we go to trial.
Oh, well, they are in the court record, and I did take those into account in the motion, so those can be considered as evidence I considered in the motion, and that'll be part of the record on appeal if you do. Understand, I can't really advise you on how all that works, but on an interlocutory appeal, the Court of Appeals doesn't get the court file. They only get that when there's appeals after a case is done. So if you're filing an interlocutory appeal, you got to file an application, and you have to attach to that application all the stuff you want them to see. They won't get the record unless they ask for it. All right. So otherwise, we'll see you all back on March 19th at 9 a.m. Good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And our first case in the morning docket is People of the State of Michigan versus Trevor McLoud, file 23-6748FH. Good morning, Mr. McLeod. And still your intention to represent yourself in this matter?
That's correct.
All right. And good morning, Mr. Juliet. Right. And Mr. McLeod, this is scheduled for a docket call, but also you filed a motion to reconsider the court's denial of the motion to suppress. I've reviewed your motion. Go ahead and say anything further that you wish to in its support.
I mean, I think it's pretty well laid out in my motion to reconsider.
Thank you, Mr. Juliet. People have a position? No. All right. Well, Mr. McLeod, I mean, your motion to reconsider is that this court doesn't have the authority to interpret the consent decree, and that you don't have to announce your status as a tribal member to DNR officers in order to be protected by the provisions of the consent decree. I mean, I'm assuming that those statements that you make are true, but it's my opinion that doesn't change the ruling in this case, because if you were charged with some kind of boat registration violation or something,
Which I was.
those may well be. Well, but that's not the violation that's in front of me.
Well, that's the initial violation for the whole reason why I'm here.
Right. But if you were charged with that, this might well present a defense. But what I'm saying is that doesn't invalidate the officers having contact with you, because they have no idea who's who out there.
Right.
To accept your argument means that they just don't get to just that tribal members could just go around and they don't even get to get stopped when the police don't even know who they are.
Well, I think this is because they're supposed to be trained to ask if we're tribal or not. Well, and in fact, in the consent decree, for them to even be qualified to handle or deal with tribal members, they're supposed to have cultural sensitivity training. And I can tell you right now that I've called my tribe and they're not on any list that's that has had that training. So they're not even qualified to approach or ticket or do anything with tribal members until they complete that training, and they've never done it. So,
well, the testimony was that the officer, immediately upon initial contact, did detect indications of impairment, and then
right. But I also proved that he perjured himself, which means his testimony is junk.
Right. So based upon his testimony, the stop was good, the investigation was good, and the motion for reconsideration is denied. So what that does, sir, I don't even know who you are, but you got to stop interrupting the process, right?
I'm sorry.
Okay. You can observe, but you can't participate. You understand there's a difference there. All right. So, Mr. McLeod, then you previously stated that it was your intention to file an application to appeal the Court of Appeals. Are you still seeking?
Well, currently what's going on is I'm filing a criminal complaint against these officers and probably a civil complaint. So I'm gonna make a move to stay at court, motion to stay at court for a bit while I get these complaints going and get them to the right authorities.
Well, I'm not gonna do that. I mean, it's one thing, you know, sometimes when people are appealing a ruling, that's different, but you're saying you want to pursue criminal or civil remedies against the officers. I don't even know what those would be. But I'm not gonna stay in this case for that.
Well, I've also got 5 more motions that I've already written and I'm returning to, so I need some time to sort this out.
Well, when are you gonna file those?
I'll file one today, you know.
Well, here's the deal, like you should file all the motions you want me to hear, and then I can hear them. And then if they resolve the case, great. If they don't, then we'll set it for a jury trial. What we shouldn't ought to do is just kind of trickle them out, so this case lasts, 2 years or something. So what I was thinking I could do today is give you a jury trial. But if you've got some more motions to file, I'll put it out for another docket call, but that'll be a motion cutoff, meaning that any arguments you got about this case, file them all, and we'll hear them all. Does that make sense?
I guess so.
Okay. So let's pick a date for that. What about April 23rd? That's in about 5 weeks. That should give you plenty of time to get your motions filed.
Yeah, that's right.
Okay. All right, so let's schedule this then for a docket call. And that'll also serve as a motion cutoff for April 23rd at 9 a.m.
I'd like to have Officer Liestenfelds and Beelman present for questioning. Could I have Officer Liestenfelds and Officer Beelman present for questioning?
Well, it depends on what motion you file.
It's gonna have to do with their testimony.
Okay, so if you file a motion that requires the testimony of the officers, then how that generally works is when you file the written motion, then the prosecutors, on notice that in order to respond to that motion, they have to bring the officers to testify. What motion do you think you're going to file that requires their testimony?
Well, I'm gonna. So in Mr. Liestenfeld's report, which you probably have in front of
I don't. I only get what you guys give me during motions.
I submitted it all. It's all in the clerk's file. But he states in his statement that once the warrant was signed, that I gave him my blood without cause, but in my documents, I've got an unsigned warrant. It was never signed. So his testimony will be impeached also. They're both lying.
Okay, so you're going to file a motion to suppress was there a blood test? Okay, blood test. Okay, and that would require the officer's testimony. So, all right. So yes, if you file a motion like that, Mr. Giuliano will bring the officers. Okay. Otherwise, he would probably lose the motion because it's his burden to come forward with that. First, this morning, we've got People of the State of Michigan versus Trevor McLoud, file 23-6748FH. Counsel for the people, you want to state your appearance, please?
Anthony Giuliano, on behalf of the people.
All right, and Mr. McLeod, good morning, sir.
Morning.
Again, every time we come into court, I'm going to be required by the court rules to confirm that you wish to represent yourself in this matter without the assistance of an attorney.
That's correct.
All right. We're here for a docket call as well as several motions that you filed up, that you noticed up. One of them does require some testimony. That was the motion to suppress the chemical test results. Your filing the motion triggers the prosecutor's burden to establish that search was taken properly. Is there any opening statement you want to make, Mr. McLeod, about your motion to suppress the chemical test results? And you'll have an opportunity to argue after the testimony as well. Any opening statement you want to make?
Well, I just received an email from Julie Rattel. I don't know if she's a court administrator or clerk.
She works in the prosecutor's office.
Okay, I just received an email from her on Friday with the warrant that was never found in Discovery or anywhere. It just turned up Friday magically, I guess.
Okay.
So I'd like to open with that.
Okay, Mr. Juliet, any opening statement?
No.
All right, and your witness?
Conservation Officer Burgoyce.
All right, Officer Burgoyce, would you please raise your right hand for me, sir? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go ahead, Mr. Juliet.
Sir, can you state your full name and spell your last name for the record?
Alexander Bourgeois, Bourgeois.
Thank you. And where do you work?
I work for the Michigan DNR.
How long have you worked there?
I got hired in July. I've been working the field since August of 2022. So 2022.
Okay. Were you working on September 4th of 2023?
Yes, sir.
Okay. And did you have some interaction with the defendant, Trevor McLoud, that day?
Yes, sir.
Is he present in the courtroom, if you can see?
I can't see, but I saw him earlier. He's in the defendant seat.
Right. Can I let the record reflect that?
September 3rd.
Can I let the record reflect the officers identified the defendant?
Yes.
Thank you. Can you describe what caused you to have contact with him?
Initially on that day, we were doing a BUI patrol, and other COs notified me and the other officers that were in my patrol boat that there was a boat with expired registration. We went to the Forks boat launch to make contact with that vessel, and subsequently we found out that the defendant was intoxicated while he was operating the vessel, and that led to the arrest of him.
How did you find out he was operating while intoxicated?
Once he had exited the vessel, I noticed that he had to use the post on the dock for his balance to get out of it. He took off his sandals, then walked to the bathroom, and as he was walking, he stumbled and swayed back and forth along the dock and up the ramp of the boat ramp to the bathroom. And then the same thing coming back. Myself and other officers observed this, and that's when we made contact with him.
Okay. When you made contact with him, were there any other signs of intoxication that you could tell?
Yes, while talking to him, I observed slurred speech. When I asked him for his documents, for his boat and his driver's license, he lacked fine motor skills. I couldn't pick through the papers. That's a common sign of intoxication. And then when he was stepping into the vessel to go get the registration for the vessel, I noticed that it took him about 10 seconds just to put on one of his sandals. That would show that he was lacking fine motor skills, couldn't put his foot inside of the sandal to put it on.
Did you perform any standardized field sobriety tests?
No, sir, the defendant refused.
Okay. So what happened after he refused the field sobriety test?
Myself and Officer Listenfeltz, we advised him that he was going to be under arrest for BUI and asked him to exit the vessel that he was in. He refused, even though we gave him a lawful order. We told him that if he didn't exit the vessel, that additional charges would be brought against him, resist and obstruct. He still refused to. Officer Listenfeltz got inside of the vessel with him. We told him to place his hands behind his back, that he was under arrest. And Officer Listenfeltz went to grab his arms to put his hands behind his back. The defendant pulled away from Officer Listenfeltz, and during this time, a scuffle erupted, and Officer Listenfeltz fell on top of the defendant. He put his arms in front of him so that way he couldn't be cuffed. During this tussle, Officer Listenfeltz was able to pull his left arm behind his back and put a cuff on it, and then the defendant still kept his right arm on his chest. At this time, I pulled out my taser. I took the cartridge off so that I could use the dry stun option. I had to tell him 4 times that if he didn't comply, he was going to get tased. And then finally, Officer Listenfeltz was able to pull his right arm behind his back and handcuff him.
Okay. So at some point, did you arrest him for boating under the influence?
Yes, sir.
And is there a procedure within the Department of Natural Resources for what to do when you arrest somebody for boating under the influence? Do you draw blood, or do you use a data master or anything like that?
Yes, sir. It's the same as if it was a motor vehicle. Obviously, with how he acted, we knew that he was going to refuse. So once we got to the jail, the Sheboygan County Jail officer listened to us when read him his DI 177, which I think it might be called something else for DUI, but his chemical test rights. And then I started typing up the search warrant because we knew that he was just going to refuse. And then we went and got the search warrant for his blood.
Okay, do you know if he actually refused, or?
Yes, sir.
Okay. And you said you were the one that typed the search warrant?
Yes, sir.
Okay. Do you have a copy of the search warrant with you?
I have it about 10 feet away from me if you'd like me to grab it.
Can he grab his search warrant? I just want to authenticate it for an exhibit.
Sure, Officer Bourgeois, if you want to go retrieve that.
I object to it. It is as exhibit. Just turned up on Friday.
Okay, well, it hasn't been offered just yet, but you're about to offer it, right?
Yes.
All right, so the objection is that it was not provided during discovery.
I mean, 3 different requests for discovery.
In
Well, I don't-
response to that.
I don't know. I mean, it's his motion to suppress the search warrant. I mean, I think I should be able to offer it as evidence.
Right, well, I mean, do you have any response to the discovery objection that it wasn't provided, or?
I do. We didn't have the search warrant in our file. We had to call up to the jail last week and get it. So when we got it, that's when we emailed it to them.
Okay, that objection, Mr. McLeod, will be overruled. It's far in advance of trial. We haven't even set a trial date. We might end up doing that this morning yet, but we don't have a trial date.
So if we're allowed to keep bringing discovery, I'd like to allow my witnesses that I forgot to call for their discovery to be brought into the case also.
For what? For what purpose?
For the trial.
Trial, yes, we haven't even, so if I set a trial date today, there'll be a deadline to file witness and exhibit lists. Okay, you'll be able to do that. Yeah, discovery's just got to be done well in advance of trial. And for purposes of responding to your motion today, then it's appropriate. All right, go ahead.
Officer, do you can you recognize who's the magistrate or the judge that signed the search warrant?
The signature is in cursive, but it looks like the first name is Mariah, and then Ellen Bowe. It's hard to read the last few letters of her signature, but there was a female that came in.
Okay. And what date was that search warrant issued?
9/3 of 2023.
If I can approach for people's proposed one.
All right, you want to show it to the defendant?
Take a copy. I don't get one sent to me.
Is that the same thing that you got on email, or?
Yeah.
Okay. Okay.
For admission of people's one.
All right, any objection to the admission of people's
Yeah,
exhibit one?
it's invalid. It doesn't have any details. It doesn't have a charge. The affidavit that's supposed to go with it is signed by the judge or by the officer. And it's completely procedurally incorrect. I wasn't provided a copy or shown that warrant at the time of the arrest. I haven't had a copy in the 3 requests for discovery.
Okay, those objections are overruled. People's exhibit one is admitted.
May I continue, Your Honor?
Yes.
Officer, did you serve the search warrant on the defendant?
Yes, sir.
And where was that at?
It was at the Sheboygan County Jail.
Okay. And did you subsequently observe blood being drawn?
Yes, sir. Both myself and Officer Listenfelds were in the room.
Thank you. I have another question.
Any questions for this officer?
Yeah. So on the day that you were out on saturation patrol, could you explain what saturation patrol is? In detail?
So, yes, sir. So, what we're looking for is it was a busy time of the year. You know, it's boating season. So, what we'll do is we'll put a lot of officers out, whether it's on the water or on land, that would be used for transportation if an arrest is made. But we look for BUI, anything to do with alcohol violations. So if we came across someone that was under the influence of boating, typically we either have officers that would take them to the jail for us, or that could go and patrol our area once we did that. But it's a large number of officers in the area specifically looking for BUI and safety issues with the boating season.
And all these officers have a pretty good training on the laws of OWI and have training on how to perform and execute these arrests.
Yes, sir.
Okay, so are you aware that according to the Natural Resources Environmental Protection Act, section 324-80176, subsection 3, that in order to approach anyone or board their vessels, if you suspect an OWI, the suspect has to be visibly impaired while underway?
Sir, you were underway. I think we covered this in the first motion you filed.
You never noted that I was visibly impaired while I was underway. In fact, you said that you did observe me through binoculars to see if my registration was expired. Is that correct?
Yes, I did use binoculars to see you underway with the vessel and that your expiration was expired, yes.
Okay, the reason why you approached me was the expired registration. Is that correct?
Well, we docked next to you to talk to you about the registration, but once we docked next to you, then we observed the signs of impairment, which even if you didn't have expired registration, I still would have made contact with you because of the reasonable suspicion of intoxication.
And when you report, you state the reason you and your partner approached me and my family was due to an out-of-date registration. Is that correct?
That was one of the reasons, yes, sir. But again, we would have made contact with you regardless of the registration because of the stumbling and swaying up the ramp.
Is it common protocol to run a boat's license number on vessels that have expired registration?
I can if I want to double check that it is actually expired, which typically I would do that if you could provide some type of registration that would prove that it wasn't. That's when that would run the number through lien to see if it actually was expired. And that if it wasn't expired, then we'd go through other avenues such as failing to display the new decal.
Okay, so would you admit that you're trained to notice out-of-date registration stickers on boats and off-road vehicles?
Yes, sir.
Okay. Is it safe to say that you likely noticed my out-of-date registration when we were actually launching our boat right next to you?
Well, we noticed your registration. Well, the other officers did, notified us of it, and then we went to the scene, observed that you were the driver that they stated was driving, that you were the vessel that had the expired registration. Everything matched, that we had the correct vessel that was pointed out by other officers, and that's when we docked next to you. Yes, I mean,
so that day, Mr. Bourgeois, that day I launched my boat right next to you guys launching into the water around 2 o'clock. Is that correct?
not that I'm aware of.
Okay, so when I was swimming with my family out in the lake and you guys rolled by us very slowly with no other boats around and waved at us, you didn't notice my registration then?
Well, so there was probably 10-ish officers. It probably wasn't me because I don't recall. And if that was you, sir, obviously we would have.
Yeah, that's fine. You answered my question.
Okay.
Is there a safety measure in place for officers to be sure that they're not encountering Native Americans on the water as they do not need registration? How do you approach that situation?
Well, sir, we treat everybody as if they're state fishermen or recreation. Once we make contact with the individual and they advise us that they are tribal, depending on what treaty they're in your case, the Sioux tribe and the 1836 treaty, we do have the jurisdiction to still check that you have everything that you're required by your tribe and continue a check. And if you don't have the stuff that you need, so say you're spearing, you have to have special permits that the tribe notifies.
Did you search my vessel that day to check and see if I had the required stuff?
No, sir, because you weren't in the act of fishing. You were driving the boat just down up the river.
So you didn't search my boat to see if there was any equipment that could indicate that I was fishing? No,
sir, because it's not applicable to the violation.
So you didn't search. So you didn't search my boat. Is that correct?
No, sir.
Okay. do you have any evidence that at the time I was operating the vessel, that my BAC was over the legal limit?
I had probable cause to believe that you were intoxicated upon the
That's
arrest.
not what I asked. Do you have any evidence?
Well, Mr. McLeod, that's not even relevant to the question here today.
Well, this whole thing is irrelevant. I mean, it's all based on hearsay and what these lying cops are talking about.
Well, this is a motion about whether the results of the blood test are admissible. So if you can direct your questions toward that question.
You say you obtained a warrant to draw my blood. That's correct?
Yes, sir.
Why wasn't I shown or given a copy of the warrant upon release?
Myself and Officer Listenfeld's actually left copies with the jail, as the prosecutor stated earlier. That's why they weren't sent by me to the prosecutor. I have the affidavit and the search warrant right next to me. I believe they made copies, or at least we left the return and tabulation, which you're required to by law. So that was left for you at the jail by us, and Officer Listenfeld's could testify this as well. But everything, all legal processes were covered by us at the jail.
Is it common procedure to not sign an affidavit that goes with the warrant?
I'm sorry, what do you mean by that? All my affidavits are all signed.
I'd like to submit exhibits from my motion to suppress. Exhibit 4, all 3 pages of exhibit 4 into evidence.
That's the warrant.
It's well, I didn't have a copy of the warrant. It's just unsigned documents that are supposed to be accompanying the warrant.
So exhibit 4 to your motion was it says warrant felony, and then it's got the signature page with no signature and the return that's not filled out.
Yeah, and actually exhibit 3 also, the affidavit of probable cause is unsigned.
Okay, the affidavit of probable cause exhibit 3. All right, and that's the 2 pages. Any objection to the admissions of those pages? We'll mark it as defendants A. No objection. All right, complete the list and mark it as defendants A.
Okay.
Yeah. All right, so those documents are admitted into evidence, Mr. McLeod.
Question.
Any redirect?
No.
All right, thank you, Officer Bourgeois.
Thank you.
Further testimony needed from him today?
No.
Okay. All right, argument on the motion to suppress the chemical test results, Mr. McLeod.
Well, I've already shown that the warrant's invalid. It's got unsigned documents that are supposed to be accompanying it. So I would say that it should be upheld, that this warrant was invalid. It was executed improperly. It was not served on me. It was not given to me upon release. It was not found in discovery with 3 requests. So it's very convenient that it turned up Friday.
All right, thank you, Mr. Juliet.
Just briefly, just based on, I understand the court has to make a credibility assessment here on whether the officer did in fact type up a search warrant and serve it on the defendant. He certainly had probable cause to draw blood. That's common procedure when somebody refuses a chemical test. The defendant displayed signs of intoxication, which led to the arrest for voting under the influence. He refused a chemical test. When offered one, based on the observations of the officer, he had probable cause to submit for a search warrant for blood. He did that. He typed out the affidavit, and it looks like, to me, it looks like it's electronically signed. On defendant's exhibit 3, he said that he served it on the defendant, left it in jail. So I would ask the court to deny the defendant's motion.
All right, well, the motion was to suppress the results of the blood test for alcohol in Mr. McLeod's body because the blood was drawn without a warrant. Based upon the officer's testimony in People's Exhibit 1, that blood was in fact taken pursuant to a search warrant issued by a magistrate. So therefore, it didn't violate the 4th Amendment. The complaint and affidavit and warrant that the defendant's referring to are the charging documents for the issuance of the charge. It doesn't have anything to do with the drawing of the blood. There was a warrant for the drawing of the blood, and it was drawn. And the officers testified that they did leave the warrant and tabulation and affidavit at the jail for him. Whether that got to him or not is frankly immaterial. Even if it didn't, that doesn't invalidate the action of drawing the blood. That would violate the Fourth Amendment if it was done without a warrant, but it was done with a warrant. So that motion is denied. Mr. McLeod, you also have a motion to dismiss on procedural grounds for a probable cause conference not being timely held or validly waived. Any additional argument you want to make on that motion?
Yeah, the waiver was supposed to be signed by both parties. That's state law, and only the prosecuting attorney signed it. And then neither my defense attorneys or myself signed it. I'm just curious how that transpired.
Hey, Mr. Juliet.
Just briefly, I did submit a response to this, and I did research the case law on this. I did confer with district court. It doesn't look like a probable cause conference was held, but I did read the case cited by the defendant in his motion that dealt with the failure to hold a preliminary examination within the statutory time period. That doesn't warrant dismissing the case. If anything, that would call for a remand, perhaps, to district court.
Remand back to district court.
But in this case, and in the case that I cited, there has to be some showing of prejudice by not holding the preliminary exam or probable cause conference by analogy. In this case, there was a preliminary exam that was held, and it was bound over by Judge Visnot. So I don't think there could be any prejudice by failing to hold a probable cause conference.
All right, yeah, and Mr. McLeod, the purpose of the probable cause conference is to see whether somebody wants to run the prelim or waive the prelim to address any bond issues. You were already free. You weren't being held in jail, and you did run the prelim. So there's, even if a probable cause conference wasn't held, there's no
probable cause
prejudice.
conference could have stopped a lot of those procedures because the probable cause is all hearsay.
No. But see, probable cause conference, the prosecutor doesn't have to prove probable cause at that hearing. They have to prove it at the prelim. The probable cause conference, it's maybe not a great name for it, but that conference is just to address, are we running a prelim? What issues might there be at the prelim? Should the defendant be released from the jail pending the prelim?
But does it not still need to be waived by both parties?
It does, but the fact that it didn't has no prejudice to you. So defendant moves to dismiss the case on the ground the probable cause conference was not timely held and that it was not validly waived.
Actually,
I'm making my ruling now, Mr. McLeod. Defendant relies on People v. Weston involving the failure to timely hold a preliminary examination for an in-custody defendant. His reliance is misplaced, however. In People v. Crawford, the Michigan Supreme Court held that the Weston remedy must be invoked prior to the preliminary examination being held. In any event, Weston did not address probable cause conference, which did not exist at the time. The probable cause conference is to address possible plea negotiations, bond matters, and the scheduling of the preliminary examination. Defendant has shown no prejudice, even if a probable cause conference was never held and not validly waived. Moreover, defendant exercised his right to the preliminary examination. Dismissal is an extreme remedy, and defendant has not shown that it is warranted. Accordingly, his motion to dismiss is denied.
you say exercise my right to preliminary. Wasn't that kind of a forced situation under duress and threat of arrest?
It's your right to have a prelim, and you exercised it. So you exercised a right and it was held. So there's no harm to you. You exercised a right. All right. Now you filed a second motion to suppress based on lack of sufficient basis for law enforcement officer to make contact. I'm not entertaining oral argument on that motion. It's just a repeat motion. Defendant moves to suppress evidence and dismiss the case based on a lack of sufficient basis for the law enforcement officer to make contact with him and a lack of evidence of his intoxication or impairment. This motion essentially raises issues that were argued in defendant's first motion to suppress. As explained previously, the officer had legitimate grounds to approach defendant based upon his observation of defendant operating a marine vessel with expired registration. Upon initial contact, the officer detected signs of impairment. Therefore, both his initial contact and his investigation were entirely lawful. Accordingly, defendant's second motion to suppress is denied. Mr. McLeod, you also filed a motion to reconsider the reconsideration. That's not really authorized in the court rules. I'm not entertaining oral argument on that. Defendant moves for reconsideration of this court's recent order denying his motion to reconsider this court's denial of his motion to suppress evidence for an allegedly illegal police contact. As the moving party, defendant bears the burden of demonstrating a palpable error by which the court and the parties have been misled, and that a different disposition must result from correction of the error. Moreover, a motion for reconsideration which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. Defendant essentially raises the same issues that have already been briefed and argued. Defendant has failed to meet its burden of demonstrating a palpable error. Accordingly, the motion for reconsideration is denied.
I think you're failing to notice or recognize the lack of jurisdiction that you have in this.
Well, that brings us to you filed 3 more things, and I want to address those today because today was the motion cutoff. So you've got a motion.
And I don't consent to that anymore either. I need more time to file these motions.
Nope. Today's the motion cutoff. You filed 3 more. I'm going to hear them today. You have a motion to dismiss for lack of jurisdiction. We've addressed the jurisdiction previously.
You don't have jurisdiction.
I already ruled that I did. This motion,
You have your own jurisdiction.
this motion is denied. This court does indeed have subject matter jurisdiction over the charges by law.
Personal or subject
and personal
jurisdiction. I object.
Your objection is noted and your motion is denied. All right, you filed a motion for disclosure of bonds. I don't even understand what you're talking about. In that
I don't
motion.
know. Somebody else handled that.
What's that?
I don't understand.
You don't understand it either? Okay.
So where did these dummies get these dumb ideas? The same place that wants you to believe your miserable aunt and closeted uncle are actually happy. The internet.
And that motion is denied. It's legally nonsense.
So all this proceed.
And Mr. McLeod, you're filing, I mean, I'm letting you represent yourself and you're filing motions that you're telling me today you don't even understand. That's not a very responsible way to proceed. There's also a motion to recognize your subrogation rights. I have no idea what you're talking about. Do you? Can you explain it to me?
It's not necessary.
All right, that motion is denied. It again is legal nonsense. All right, the time for motions has come and gone.
I don't consent to that.
Well, you don't have to consent to that. I gave you a motion cutoff. All the motions have been denied. Now is the time, Mr. McLeod, where you have the constitutional right for a jury trial. So I can set this trial for, would 2 days suffice, Mr. Julia?
I think we could probably do it in 1 day.
All right, well, just to be safe, we'll schedule it for 2 days then. I can schedule this for a jury trial, Mr. McLeod, on Thursday, Friday, August 8th and 9th. And what we'll do is we'll be here Thursday, August 8th to select the jury. And then we'll go immediately into the trial. As needed, we can, we'll continue into Friday. I'll have you both file witness and exhibit lists within 21 days of today's date. Also, I'm going to have you file, any side that wants to, I mean, the people have to, if you want to, you can as well, proposed jury instructions by 21 days from today.
I motion to stay the court while I leave to bring this into the Western District Federal Court where it's supposed to be held. There's questions that you're answering and having opinions on that you don't have the jurisdiction to have answers. I brought that up in several motions and you keep claiming that you do. It's clearly written in the consent decree that you don't.
That's manifestly untrue, Mr. McLeod. I mean, the consent decree doesn't mean that you can drive around on a boat drunk. And if the police catch you doing that, that comes in state court. It doesn't come in federal court.
Aren't you supposed to be an unbiased participant?
I am unbiased. You may not have been drunk. That will be for the jury to decide. I'm just saying I have jurisdiction over that allegation. It's not a federal.
You're interpreting the fact that you're trying to say that I was supposed to notify him that I'm Native American, and that's not true. And that's your interpretation. You're having an opinion.
All right, that's fine. And if I'm wrong, another court can tell me that
So I
I'm wrong.
motion to stay the court so I can take this to the proper court for an opinion on what you're trying to have an opinion on that you're not allowed to have.
Denied. You can go to that court, and if they stay it, they'll stay it.
Okay.
So what we're going to do is we're going to have within 21 days of today, both sides will file jury instructions and witness lists and exhibit lists for trial. We're going to come back for a docket call on May 28th at 9:30 in the morning. in person here in the courtroom, and jury trial is scheduled for August 8th and 9th. Anything else today, Mr. McLeod? That's fine. Well, you don't, I mean, I'm giving you your jury trial, right? So you can have a jury trial. The jury's going to decide if you're guilty.
Trial by jury is what I require.
What's that?
Trial by jury, correct?
Yes, it's trial by jury. Yeah. All right. Anything further, Mr. Juliet?
No.
All right. Have a good day. Good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access to this hearing both in the courtroom and also online. And our first case this morning is People v. Trevor McLoud, file 23-6748FH. Counsel, you want to state your appearance, please? All right, and Mr. McLeod, do you still desire to represent yourself, sir?
Yeah.
All right, and I'm required to remind you at each hearing that you do have the right to be represented by an attorney, including an attorney at public expense if you qualify and request. And do you wish to have an opportunity to hire an attorney or to seek appointed attorney or no?
I don't want to make that decision right now.
Okay, so you're continuing to represent yourself there.
That's correct.
All right, and you understand that you have those rights. Okay. All right, well, we're here for a docket call that I had scheduled because Mr. McLeod had requested a jury trial and I wanted to touch base and have you both submit proposed jury instructions, which I did receive. Thank you both. So what I want to do is I'm going to have ask the bailiffs to deliver to you two packets. One is the ones that begin with 2.1. Those are the preliminary. It's for defense attorneys. The preliminary jury instructions, and then the 3.1, or the ones that start 3 point. Those are the final jury instructions that I would propose to give. So those will be for your review. And I want to discuss a couple things about that. The count one, the defendant is charged with contravention, resisting, obstructing. That's a bit of a strange statute. There's no model jury instruction for that charge precisely. The prosecutor based it on 13.2, which I think is correct. Although I did amend the prosecutor's requested charge to add some language from 13.1 that is also a correct statement of the law. Particularly the statement that the defendant must have actually resisted by what he said or did, but physical violence is not necessary. And then also, because Mr. McLeod, you've raised a lot of legal challenges in this case that I have denied. Typically, challenges on the law are for the court to decide and not the jury. And you wouldn't be able to present those arguments to the jury. However, because you're charged with resisting and obstructing the conservation officer, the lawfulness of the officer's actions is indeed an element of the offense. So I am required by law to instruct the jury on the framework that they need to decide that in. So I've included some language for that the prosecutor did not request. So I want to read my instruction on count one that I'm going to be reading at the trial. And then that in count one, the defendant is charged with the crime of assaulting, battering, wounding, resisting, obstructing, opposing, or endangering a conservation officer who was acting in the performance of his duties. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered Dan Listenfeldt, who was a conservation officer performing his duties. Obstruct includes the use or threatened use of physical interference or force, or a knowing failure to comply with a lawful command. The defendant must have actually resisted by what he said or did, but physical violence is not necessary. Second, that the defendant knew or had reason to know that Dan Listenfeldt was then a conservation officer performing his duties at the time. Third, that Dan Listenfeldt gave the defendant a lawful command, was making a lawful arrest, or was otherwise performing a lawful act. A conservation officer may make an investigatory stop of a vessel if that officer has, based on objective facts, a reasonable and articulable suspicion of a violation of law. A conservation officer may make an arrest without a warrant if that officer has probable cause to believe that the defendant has committed a crime. Probable cause exists where the facts and circumstances within an officer's knowledge and of which he has reasonably trustworthy information are sufficient in themselves to warrant a person of reasonable caution in the belief that an offense has been or is being committed. Defendant is a member of a Native American tribe that is a party to a federal court consent decree that binds the state of Michigan and its law enforcement officers. Under the terms of that consent decree, tribal members operating boats or other vessels who are engaged in the exercise of a treaty-related hunting, trapping, fishing, or gathering activity shall not be subject to state vessel registration requirements, provided that the tribal member satisfies tribal license requirements for the activity in question, is in compliance with the applicable tribal hunting, trapping, or fishing season limitations and tribal law adopted pursuant to the decree, and possesses evidence of being currently engaged in hunting, trapping, fishing, or gathering, such as fish, game, or common items related to hunting, trapping, fishing, or gathering, such as fishing rods, tip-ups, firearms, traps, or nets. Fourth, that the defendant's actions were intended by the defendant, that is not accidental. So in instructing the jury on the framework for which they should consider whether the officer's actions were lawful, I'm including in that instruction black letter law on reasonable suspicion and probable cause for a stop and rest, and I've included the direct quote from the consent decree that I believe is the provision that you've been arguing, Mr. McLoud. Mr. Juliet, do the people have any objection to that instruction?
No, Your Honor.
Mr. McLeod, do you have any objections to that instruction to the jury for the trial? And then in count two, the is the operating a motorboat while intoxicated. My model instruction is not that was requested by the prosecutor. I model it on the OWI vehicle as did the prosecutor. However, the charging document in this case, the information, there's two ways to charge someone with operating while intoxicated. One is an under the influence theory, and one is a over the limit theory. The information in this case did not include the over the limit theory. It included only the under the influence theory. So my instruction only includes that. So the instructions the prosecutor proposed for the being over the 0.08 limit, that's not what's been charged, so I'm not getting that. So the instruction would be as follows. In count two, the defendant is charged with the crime of operating a motorboat while under the influence of alcohol. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motorboat. To operate means to drive or have actual physical control of the motorboat. Second, that the defendant operated the motorboat on the waters of this state. Third, that the defendant was intoxicated. That is, the defendant operated the motorboat under the influence of alcohol. Under the influence of alcohol means that because of drinking alcohol, the defendant's ability to operate a motorboat in a normal manner was substantially lessened. To be under the influence, a person does not have to be falling down or hardly able to stand up. On the other hand, just because a person who has drunk alcohol or smells of alcohol does not prove by itself that the person is under the influence of alcohol. The test is whether, because of drinking alcohol, the defendant's mental or physical condition was significantly affected and the defendant was no longer able to operate a motorboat in a normal manner. Mr. Juliet, do the people have any objection to that instruction?
No, Your Honor.
Mr. McLeod, do you have any objection to that?
I'd like to include visibly impaired in that, like the law says.
You'd like to include visibly impaired as a lesser included offense?
No, I'd like the language to include that, like the law states, that I have to be visibly impaired while operating.
Well, visibly impaired, operating while visibly impaired is a lesser offense than operating while intoxicated.
But the statute under the conservation, section 8 says this solely in the case to a vessel that is being operated while visibly impaired. It's written visibly charged.
Right. But the that statute.
It's number 8. Or number 5, I think.
Yeah, subsection 3, a person shall not operate a motorboat on the waters of the state when due to the consumption of alcoholic liquor or a controlled substance or both, the person's ability to operate is visibly impaired.
Ability to operate is very correct.
Right.
And then I'd like to include number 8 from that same.
Oh, the definition of operate as used in this section, operate means to be in control of a vessel propelled wholly or in part by machinery while the vessel is underway and is not docked at anchor, idle, or otherwise secured.
Right.
All right. I will include the definition of operate under subsection 8. Under the second element where it says second that the defendant operated a motorboat in the waters of the state, operate means, and then I'll give the statutory instruction. But Mr. McLeod, the operating while visibly impaired is a lesser offense. So I can instruct the jury if you request, and I can change the verdict form to this effect too. That says that they can consider whether you're guilty of the operating while intoxicated, or they can consider the lesser offense of operating while visibly impaired. The operating while intoxicated is a higher burden to prove. The language under the influence of alcohol legally is a higher burden than the visibly impaired. So sometimes defendants want the lesser included as an option. Other times they don't, because they don't think that the higher burden would be met. But so what I would not do, I would deny your request to like combine them into one instruction. But if you want the visibly impaired given, that's a lesser offense. And I'll let you think on that. We're going to come back for another docket call in July. If you request a lesser included, we'll do that. I'll make a note, possible lesser included impaired. All right. A couple other things. For jury selection with Mr. McLeod representing himself, I think the law does allow the court to conduct the voir dire, and I'm going to go ahead and do that. So I'm signing an order today that on my own motion, I will examine the prospective jurors during jury selection and not allow direct questioning from either the prosecution or the defense.
I object to that.
Noted and overruled. But I'm giving both sides, as required by the court rules, an opportunity to submit written questions. So you have to submit written questions to me not later than Tuesday, July 2nd, so I can review them. And we're going to come back for a docket call on July 9th at 9:30 a.m. And then I will not ask questions that I determine are improper, irrelevant, or unnecessary.
Sorry, you don't have a jury of my Native Americans, my peers.
No, sir. It's a jury selected at random from folks in the county. All right, and also, Mr. McLeod, you've waived your right to counsel, and we've gone through the waiver process, and I believe that you have knowingly, voluntarily, and understandingly waived the right to counsel with your eyes open as to the risks of self-representation, that you're choosing to exercise your constitutional right for self-representation. That, of course, doesn't allow you to become disruptive to the court processes. You've not been doing that of late, but there was some history early on of that. So under Supreme Court precedent for Ferretta v. California in 1975, this court may, even over objection, appoint what's called standby or advisory counsel to aid you if and when you ask for help, or to be available to represent you in the event that the termination of your self-representation is necessary. So therefore, on my own motion, I'm appointing the Sheboygan Office of Assigned Counsel, not to act as your attorney, Mr. McLeod, but to act as what's called a standby or advisory counsel. So they'll be present at the hearing in July and at the trial. They won't participate. They'll be there to give you advice if you have any. If you don't have any, they won't give it. And then if, for example, you became disruptive during the trial to the extent that even despite warnings, you persisted and had to be removed, then the attorney would jump in and finish the trial on your behalf. But as long as you're not disruptive, that's not going to be an issue. But they're there just as advisory counsel for you. All right, Mr. Juliet, any objection to that?
No.
Mr. McLeod, do you have an objection to that?
I object. I want to represent myself.
And I'm going to let you represent yourself, but I am going to appoint a standby or advisory counsel. just to assist you if you deem necessary. And then I did notice as I reviewed the witness and exhibit lists that were submitted by both parties, Mr. McLeod, you had listed both magistrates in the district court judge, probate court judge, the elected prosecutor, and a retired circuit judge. Can you tell me what
It's all pertinent to the situation.
in what respect, what testimony do you think that they'd be offering would be relevant at the trial?
Do I have to, I don't need to say all that right now.
Yeah, you got to tell me that it's relevant because I don't see how that's possibly relevant.
Well, the magistrate and the prosecuting attorney went ahead and prosecuted this case without having a warrant on file. The judges all looked through this file, didn't have a warrant on file, still pursued it. So I mean, it's kind of like your job, isn't it, to make sure all the paperwork's in order?
Sure, but that's not relevant to what the jury has to do. What the jury has to decide is whether the officer's actions on that day were lawful and whether you were resisting him and or operating a motorboat while intoxicated.
Not guilty if he is guilty of a charge.
One more outburst and you'll have to leave. So the
I mean, as long as it's
the judge's testimony, magistrates and prosecutors not admissible or relevant. So I'm going to strike from your witness list Magistrate Ellenboss, Magistrate Libby, retired Judge Spartan, Judge Vizina, Prosecutor Goodrich, and retired Judge Pavlich. So you may not call those folks as witnesses. Right. And what we'll do then is come back for, you both have until July 2nd to come back for, or you both have until July 2nd to file witness and exhibit lists, or I'm sorry, to file requested questions that I would ask the jury during jury selection to achieve a fair and impartial jury.
we're not going to get a fair and impartial jury because they're not going to be Native Americans. It's the whole situation.
Well, that doesn't, if somebody's African-American, we don't seat an entirely African-American jury. If somebody's Asian-American, we don't seat an entirely
It's
Asian-American
not
jury.
true, not yours.
It's not, well, sure.
The argument that I'm
It's
fighting is
yours.
based on the treaty rights. That's the whole thing about it.
Yeah, in fact, it would violate the Constitution if I tried to seat a jury of only Native Americans and excluded people based on their race. So I will decline your invitation to engage in racial discrimination in jury selection. So you have until July 2nd to submit written questions, and we'll come back for a hearing on July 9th at 9:30 so I can tell you which of those questions I'm asking or not asking. I'm granting Mr. McLeod's request to add the definition of operating, and we'll give him until the 9th to decide if he wants the lesser included or impaired instructed.
Is that the 9th or the 2nd?
The 9th, yeah. The 9th is the hearing. And we are still scheduled for jury selection August 8 and 9. All right, anything further for today from the people?
Just briefly, Your Honor, while we're on the record, Mr. McLeod and I have been undergoing continued plea discussions. I guess I would just ask the court its position on a few possibilities for resolution.
Okay.
I know in the past with some cases we've done a plea to a felony with a very short term of a delay with a dismissal at the end. Is this the type of case the court might consider something like that on?
Yeah, I mean, from what I've learned about the case in the pretrial motions, although your legal arguments have been unavailing, Mr. McLeod, I don't think your underlying conduct in this case was all that egregious. And so, I mean, I'm not looking to lock you up, even if you're convicted after the trial. So whatever negotiated outcome you guys could come up with, I would have no problem with. I don't think your behavior was extreme.
Can I motion for summary judgment?
What's that?
Can I motion for summary judgment?
Well, no, I mean, you already did. There has to be like legal grounds to dismiss, which I've denied, or that there's not enough evidence of probable cause to go forward, which I've denied. There is probable cause to go forward to a jury. So I can't decide it instead of the jury. I mean, you could waive your right to a jury and have a trial in front of me, but both sides would have to agree to that. Or if you wanted to enter a plea of guilty or no contest, the charges or some lesser charges as the prosecutor and you sort out, you can do that as well.
Well, right now, what he's proposing is a disturbing the peace with no probation, no jail, and a week delayed sentence to get it off the record. I would like to add to it, no fines, no cost, because I already paid to drug testing and all that stuff for the first 4 months. And I'd like to also add to it that the week delayed the time served because of the time we spent doing drug testing.
All right, well, and if you guys come up with a negotiated outcome, then there are things that you both can agree to, and then there's things that you can leave. If you're not agreeing to them, that you both can argue to me, and then I can decide, you know.
Well, that's where we're at right now. Let's do it right now.
All right, so I think what we'll do then, just because I haven't scheduled anything else on the August trial date. Sometimes I schedule backups, but I haven't done that in this case. And because I want to preserve the ability to use those dates or something else, I'll indicate that the July 9th hearing will be a plea cutoff as well. So if there is any kind of,
Well, I guess what I'm wondering is if I take this plea, is it something I agree to?
well, I haven't heard clearly what the plea would be.
Well, I guess he's accurate that I did offer a disturbing the peace, but I know this court doesn't do misdemeanor probation, so I think it would have to be a plea to the 2-year on a week delay with a dismissal at the end. It's technically felony probation. I'm willing to give him a disturbing the peace, but again, I don't think this court would.
Wait, you want to do a disturbing the peace with a delay and dismissal?
No, well, I'm fine with that, but I don't think this court will do a misdemeanor probation.
I would do a misdemeanor delay with a dismissal if it's a short delay, and I wouldn't have Department of Corrections supervise them. I would just supervise it internally with the court staff.
Okay, I will get that drawn up then.
If you reach an agreement and you want to come in before July 9th just to get it done, just contact court staff and we'll schedule a time for you to come. Any other questions, Mr. Julian?
No.
Mr. McLeod? Okay, all right, we'll be in recess. All right, good morning. We're on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. Our first case this morning on this morning's docket is People versus Trevor McLoud, file 23-6748FH. Counsel, you want to state your appearances, please?
Anthony Julia, yeah, people.
And Mr. Wargo, you want to come on up? You've been appointed as standby counsel in this case.
Your Honor, my apologies. I'm not familiar with the standby counsel process, and I just found out about this morning.
Well, all right, that's not my issue. We appointed the Office of Assigned Counsel May 28th. Accordingly, in this court's own motion, the Sheboygan Office of Assigned Counsel is hereby appointed to act as standby/advisory counsel for defendant and shall appear at all hearings scheduled in this case, including the docket call on July 9th at 9:30 a.m. and the jury selection and trial August 8th and 9th. And the clerk's office would provide notice to standby counsel as well. Notice has been provided. We confirmed with your office that you were the one. All right, Mr. McLeod does not appear to be present in the courtroom. Is he in the hallway? He's not in Zoom either. He's not appeared. Have you had any contact with Mr. Trevor McLeod?
To my knowledge, the entire office is not here, Honor.
All right, well, Mr. McLeod has been representing himself. I did appoint standby counsel at the last hearing. Standby counsel is present. But since the last hearing, Mr. McLeod has refused to accept mail from the court. We sent a mailing to him with copies of the orders that I entered at the last hearing. It was sent back to us with a red marker stating return to sender and offer to contract is denied. So sadly, Mr. McLeod seems to be retreating back into nonsensical sovereign citizen defenses. And he filed a document, or there's a document purported to have been signed by him entitled Letter Rogatory for Relief that is legal nonsense that somehow accuses the court of somehow generating funds from the case using defendant as some security mechanism, which makes no sense at all. This is not the first problems we've had with Mr. McLeod, and now he's choosing to refuse service from the court and refusing to attend here today. We have a jury trial scheduled August 8th and 9th. Mr. Juliet, any requests from the people?
This is his first failure to appear, to my knowledge, but I wasn't aware that he was deliberately refusing correspondence from the court. So based on that, I would ask for a bench warrant.
All right, Mr. Wergo, any input from standby counsel?
Yes,
you don't represent him, but you're here to stand by and you're here to give him advice if he is here, if he wants advice, and to stand by to represent him if he's not able to represent himself, and him not being absent, I guess, if you want to say anything on his behalf.
Yes, Your Honor. Being that it is his first non-appearance, and it appears that he is maybe under the impression that there are some legal mechanisms at play that aren't, I would ask that instead of a bench warrant, the court issue a show cause and allow our office an opportunity to try and work with him.
Well, he's not only not here today, he's refusing to accept anything that we're sending him. He's repeatedly demonstrated contempt for this court's authority and process. I'll issue a bench warrant for his failing to appear with no bond. Do we leave the trial date on for now, Mr. Juliet?
Yes.
Okay. Normally, I would cancel the trial date. I'm going to give Mr. McLeod the courtesy of not canceling that trial date because I don't want him to be sitting in jail for a super long time on this case. But I guess my staff will monitor that. If he's not in custody soon, we'll be canceling that date and using it for other cases.
Are you Wergo? Mr. Wergo?
No, it's Mr. Varga for arraignment purposes. All right, we are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online, and we're here to arraign on a bench warrant Mr. Trevor Kenneth McLeod. It's file 23-6748FH. Counsel, please state your appearances.
For the record, I'm sorry.
Anthony Julian on behalf of.
For the record, Ronald Varga, mine with Mr. McLeod in these matters. Mr. McLeod, when I did meet with him, indicated he wanted to handle this hearing himself.
All right. Well, Mr. McLeod, it's alleged that you are in contempt of court for failing to appear on July 9th at 9:30 a.m. for a 53rd Circuit Court hearing. You've got the right to a hearing on that allegation where it would need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at that hearing. If you are found to be in violation, if you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. I can also revoke your bond if you're not complying with the terms of your release. Do you understand the rights and penalties that you have in front of you, Mr. McLeod?
Sure. I was under the impression that this was all going to be over with by now that we're.
Nope. Nope. All right, Mr. McLeod, and also, so you know the rights and penalties that I outlined for you? You understand those?
Yeah.
All right. Mr. Varga, do you know how he wishes to proceed?
No, he indicated he would enter his own plea.
Mr. McLeod, you're indicating you want to represent yourself?
Well, I thought that can I say a couple things first?
No.
Okay.
You can answer my questions.
Sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, return to sender, and offer to contract is denied. Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd, and demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLeod in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard and ruled against. And now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this manner without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself, and I'm appointing Mr. Wirgo to represent you as a lawyer.
Okay, it's Mr. Wirgo here.
If the Office of Assigned Counsel determines that Mr. McLeod is not indigent or is only partially indigent, that office may petition this court under the applicable statute for contribution from Mr. McLeod for the cost of representation. So, Mr. Varga, you want us to set this for a hearing then?
I do.
All right,
I do plead not guilty.
all right, Mr. McLeod will enter a plea of not guilty on your behalf as to the contempt. So we have to schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLeod, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Is the court want to entertain a bond on this matter, Your Honor? To my understanding, Mr. McLeod is a local resident and he has met, with the exception of the last court date, that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates. Okay. And he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future.
I will not have to do. Make sure.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak?
the court rule. So he's made it clear he doesn't want to take this serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail, and I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really relying on me. This would be a really big problem if I get this revoked at this stage.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating boats under the influence of alcohol. You think that law doesn't apply? It does.
That wasn't.
And when a law enforcement officer sees you violating that law, you can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLeod, there's a third branch of government that does exist. And it exists for the orderly resolution of those disputes, those allegations, with full protection of your rights, as opposed to some kind of vigilante justice system. You may not agree with this, but this court has diligently tried to protect your rights and afforded you a respectful and lawful process. You have disrupted and ignored that process. You have disrespected that process time and again. That subjects you now to contempt of court and revocation of bond. Most people, Mr. McLeod, learn this lesson the easy way, but it seems that you now have to learn it the hard way. You're remanded into custody of the Chagrin County Sheriff, and will next see you, sir, with your lawyer, Mr. Wordbell, on August 20th at 10 a.m.
So, can I really say?
Good afternoon again, Your Honor. Custody on behalf of Trevor McLoud.
All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
Goodrich, Wayne County Prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter.
I do see that the new charge is set for an arraignment on September 10th it was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice. He's now retained counsel. To my knowledge, he had no failures to appear. He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but sure, he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had to lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold his listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you. Ms. Gooders, people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to represent, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case. So this was really quite a willful refusal to acknowledge even the authority of the court, and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLoud respects the authority of any governing authority, and that he would appear. He's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
Thank you.
Thank you.
All right, Mr. Kukeski, let's call Mr. McLeod's matter.
Good afternoon, Your Honor. Kukeski. McLeod.
All right, and this is file numbers 24-6892 and 23-6748. And we're here for a docket call on both matters, and some motions that are noticed up. And do you know how we're proceeding today, Mr. Kukeski?
I do, Your Honor. At this time, my client would be offering a plea to the court that he would be pleading to in file 23-6748, count 1, resist obstruct, and then amended count 2, impaired marine safety. In file 24-6892, he'd be pleading to absconded and misdemeanor.
Okay. And we have amended informations. Do you consent to the filing of the amended informations, Mr. Kukeski?
I would, Your Honor, yes.
I did have a signed advice of rights. I'm not sure if the court.
I do. I have it.
Okay.
All right, Mr. McLeod, would you please stand, and as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Put your hand down. And Mr. McLeod, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. At any time, if you've got any doubts, questions, or hesitations, just let me know. I'm happy to answer any questions you may have, and I'm happy to give you more time to talk to Mr. Kukeski if you need. Do you understand that?
I do.
All right. Now, I have to advise you the maximum penalty that you face on the in the file 23-6748. You'd be pleading to resisting and obstructing a conservation officer. That is a high court misdemeanor punishable by a maximum of 2 years and or $1,000 fine. And count 2, marine safety operating while impaired. It's a misdemeanor punishable by up to 93 days and or a $300 fine and or 45 days of community service. The court will suspend your privilege to operate a vessel for at least 6 months to indefinite. The court can order you to repay the costs of prosecution and emergency response. In file 24-6892, you'd be pleading guilty to absconding on a misdemeanor bond as a lesser offense. That's a misdemeanor punishable by up to 90 days and or a $500 fine.
Your Honor, I believe that he hasn't been arraigned yet on the 24-6892. I don't know if we have to do that before the plea.
Oh, that's true. This was an arraignment date on that file. So in 6892, Mr. Kukeski will arraigning him on the amended information. Do you wish to have its allegations read?
We waive the reading, Your Honor.
Okay. Is a forensic center referral requested in that file?
No.
Okay. All right. Thank you, Ms. Goodrich. Okay. All right. So, Mr. McLeod, do you understand the maximum penalty that you could face for that?
I do.
Okay. And also, there's a pending contempt citation for failing to appear, and the factual basis you'd put on the record for the absconding would also constitute a factual basis for me to find you in contempt. And that penalty is a maximum of 93 days in jail and or a fine of up to $7,500. Do you understand that, sir?
I do.
All right, and the absconding charge, well, with it being a misdemeanor, it would be, I don't think it'd be consecutive anyway. Okay. All right, so did you read and understand the rights listed in the advice of rights form that you signed here?
Yes.
Do you have any question for me or for Mr. Kukuski about any of those rights? And do you wish to give up those rights and enter these pleas here today?
Yes.
If I accept your plea, you waive any claim that it was caused by any promises or threats. And if there were any such things, you'd have to tell me today. Tomorrow would be too late. Do you understand that?
I do.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application to a higher court. And the types of issues that you could raise on that appeal are much more limited after a plea than they would be if you were convicted after a trial. Do you understand that?
I do.
All right, the plea agreement provides in exchange for your plea to those charges that I outlined, the prosecutor will dismiss the original counts and the habitual offender notice. And there's a requirement, there's a sentence agreement that they would run concurrently, which I think with the plea to the misdemeanor would be required by law in any event, but the sentence agreement just locks that in. And also a sentence agreement for no immediate jail at the time of sentencing. Do you understand the terms of that plea agreement? Mr. Kukuski, is that a full, fair, and accurate statement of his terms?
It is, Your Honor.
Mr. Juliet?
Yeah.
I'm sorry, but whose hand? Okay, I'm sorry.
That's okay.
All right, Mr. McLeod, that sentence agreement is not binding on the court, meaning if I did not want to follow it, I would not have to. But if I did not follow it, you would be allowed to withdraw your plea, not having received what you bargained for. Do you understand that? Now, there's one exception to that. That's if you were to engage in any misconduct between now and then, including new crimes or violations of court orders, then by that misconduct, you'd be forfeiting the right to withdraw the plea, even if I didn't follow the sentence agreement. Do you understand that?
I do.
All right, Mr. McLeod, other than that plea agreement, has anybody promised you anything to get you to plead guilty today? Has anybody threatened you to make you do so?
No.
Is it your own free choice to enter those pleas?
Yes.
Knowing all this, how do you wish to plead in file 6748 to the charge of resisting, obstructing conservation officer list offense?
Guilty.
How do you wish to plead in count 2 to operating a vessel while impaired?
Guilty.
And how do you wish to plead in file 6892 to absconding on a misdemeanor bond?
Guilty.
So, Mr. McLeod, back in September of 2023, were you operating a motor vessel on the waters of the state of Michigan?
Yes, sir.
And was that within the confines of Sheboygan County?
Yes, sir.
Before you had operated that vessel, before or during, I guess, had you consumed alcoholic beverages? And did you end up having any kind of breath or blood test to determine the level of alcohol in your body? Do you recall what the results of that test were?
We had 1-3.
Okay, and do you acknowledge that that is above the legal limit in the state of Michigan?
I do acknowledge that.
All right. And did you have some contact with a conservation officer listed fellows?
Yes.
And did that officer give you some lawful commands?
Yes.
And did you fail to immediately obey those commands?
Yes, that's correct.
All right. And then you were on a bond in that case representing yourself in that matter. Is that correct?
Yes.
And did you fail to appear for a court hearing in that file?
That's correct.
And then that resulted in a forfeiture of your bond?
That's correct.
All right. Mr. Kukuski, are you satisfied with the factual basis to all three counts?
I am satisfied, Your Honor.
Ms. Goodrich?
Yes.
All right. Mr. Kukuski, are you aware of any other promises, threats, or inducements?
I'm not aware of any.
Ms. Goodrich?
No, Your Honor.
And Mr. Kukuski, do you believe that I have complied with the requirements of MCR 6.302?
I believe the court has.
Ms. Goodrich?
Yes, Your Honor.
All right, Mr. McLeod, we've asked you a lot of questions. We've given you a lot of information. I just want to confirm for you that that's your own free choice to enter these guilty plea hearings today.
That's correct.
Well, Mr. McLeod, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I'll accept your pleas in both files. I will also find you in contempt for the pending contempt citation for failing to appear. we need to set a sentencing date. So let me ask you, the intent of that sentence agreement, no immediate jail, no additional jail at the time of sentencing, does that contemplate that he'd remain in custody until that date?
Yes.
Okay. Agent Fagan, Agent Young, I know you're kind of short-handed. Do you know how quickly you could get a pre-sentence report done in, I would only, let's see.
I do have a motion before the court on the bond issue. I would forego the motion with regards to the absconding charge.
Okay, gotcha.
I,
Okay, well, let's hear the bond motion before we set a sentencing date.
Very good, Your Honor, and thank you. Your Honor, I know Mr. McLeod has had, I guess, some difficulties with court here. He certainly admits those, acknowledges that, is moving forward in a positive direction with this case and with his acceptance of responsibility today, Your Honor. He's taken another step in that positive direction with the court. I did provide, as part of my motion, several letters from individuals who he's contracted to do work for, outside work that would require him to be working outside. And obviously, we're getting into sort of a colder months. Those jobs, I believe, if he's continuing to be incarcerated, he'll lose those jobs. He's got money out there on materials. He's the sole provider for his family. He certainly acknowledges he's got to come to court. He missed his court appearance. He was arrested on a warrant, and he sat sentence. He sat probably 45 to 50 days, I would imagine. He says closer to 60. But we're asking for some mercy from the court to allow him on bond. We would take a tether if Your Honor thinks that would be appropriate or feels that would necessarily make him appear for court. He will be here for the sentencing. He obviously, just to please, the resist obstruct is the charge that he has pled to, that the court would be sentencing on the highest, I guess, possibility of incarceration. He doesn't score up too high in my book. I didn't have him scoring up very high at all. If he does violate and he doesn't show up, he obviously loses the agreement with any further incarceration or no immediate incarceration that me and the prosecutor have entered on that. I think the message has been sent, just to say the least, and we're just asking the court look into its heart. The judge one time told me not to sentence or make a decision for a place of anger, to step back and just reasonably go forth an order or an opinion. And I think that's no better wisdom has been said in these matters. And so we're asking the court just for a reinstatement of his bond. Whatever additional conditions the court wants to put on there, we would gladly follow those conditions and abide by those.
Okay. Well, I assure you, I'm not angry at Mr. McLeod. We've just been trying to move the case forward and in a responsible way. Ms. Goodrich, people's position.
Oh, Your Honor, I would ask to deny that motion. Apparently, there's some miscommunication between Mr. Kwiatkowski and I, but my intent in that plea agreement was that Mr. McLeod would sit until time of sentencing and then no immediate sentencing thereafter. He has not done well on bond, so it's my intent to get to sentencing and include that matter. So I would ask the court to deny that based on his performance on bond.
Are there other bond violations that he's been brought to the court on? Yeah, no.
No, I don't.
I don't think I was familiar with
it. All right, well, I guess is your position that if he's not in custody from today forward, that entitles you to withdraw from this plea? Is there some ambiguity about the meaning of that sentence agreement, or?
Yeah, I think there was some miscommunication. I thought the intent and what we had discussed was that he would sit until sentencing, and then that's some of the reason that consideration was given in the plea offer that was given.
Okay, and that is typically
I did not.
That's typically the practice where it says no immediate jail at time of sentencing versus sometimes if it's going to be at time, then there's a stipulation for release. I guess that brings me to my next question. Agent Fagan, Agent Young, I know you're short-handed. I would, well, could counsel approach for a second? All right, and back on the record, I wanted to consult with counsel about possible sentencing dates. And so, Mr. Kukuski, would you waive the requirement of a pre-sentence investigation in this matter?
I would, Your Honor.
Ms. Goodrich, would the people waive it?
I would.
Okay, it's a high court misdemeanor. Obviously, it's not a case where we'd be sending him to prison, so I think we can certainly waive the requirement of a pre-sentence report. That means, Mr. McLeod, that we can schedule your sentencing on a much more expedited basis. So I'll deny the motion to reinstate bond at this time, but we'll schedule sentencing for 1 week from today, September 17th at 11 a.m. And I'll hear allocution from both sides at that time. If you wish, either side can file a written sentencing recommendation memo, but it certainly isn't required either. But I won't require the DOC to prepare any pre-sentence investigation. All right, so we'll see you next week at 11 a.m.
Thank you, Your Honor.
Thank you.
All right, we're back on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we have a sentencing in People v. Trevor McLoud, file 23-6748 and 24-6892. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
Luke Kukuski on behalf of Mr. McLeod, Your Honor.
Mr. McLeod, could you please sit up a bit? All right, and we're scheduled for, as I said, sentencing in both these files and also the underlying contempt sentencing. And I did not refer it to a pre-sentence investigation, so we don't have a pre-sentence report. And again, Mr. Kukuski, you and your client waived preparation of that report.
That was correct, Your Honor, yes.
Okay, anything you want to say on behalf of your client?
Just briefly, Your Honor, Mr. McLeod has certainly learned a lot through this process. I know he's eager to get out to start working for his family again. Like we mentioned last week, he does have several jobs out there lined up. His kids are back in school, and he's just eager to get back to his family with the agreement of no immediate incarceration at time of sentencing. We're hopeful that Your Honor would allow him to be released today, either on a term of probation or just released on the matters at hand with the convictions that he's going to have going forward. With that being said, Your Honor, we ask that you follow the agreement that we had. Thank you.
All right, thank you, Mr. Kukuski. Mr. McLeod, you don't have to make a statement today. If you don't, I don't hold that against you, but you are also allowed to make a statement. Is there anything you want to say, sir?
I just want to reiterate what Mr. Kukuski said, that this was a major learning process for me. The judicial system. Unfortunately, it was not in the best way.
I'd agree. Yeah. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, you could see the change in Mr. McLeod at the plea taking process, and here today, I give credit to his counsel for also that change in behavior. I would ask not for any probation or any further incarceration. I believe that the 69 days he has served has addressed the situation. Thank you.
All right, thank you. Well, Mr. McLeod, you have an unremarkable criminal history. And this was a pretty straightforward marine boating while impaired charge at first, and then you didn't cooperate with the officer, and then didn't show up for court, and that resulted in your incarceration and spending time in jail that I never wanted to give you. And the prosecutor, I hope you're listening to what she said, the prosecutor never wanted you to spend 69 days in this case. And you had a lot of things you wanted to say in this case, which is your right. Okay, today is the anniversary of the signing of the Constitution of the United States. We take it very seriously. And you had a right to tell us all those things you wanted to tell us, whether they're legally correct, whether they're legally incorrect. You have a right to present arguments. We tried to give you a respectful forum to present those arguments. I let you represent yourself. And I don't know, where you got some of the information you got. about that the courts just don't have any authority. It's easy to think about, well, let's say you were right and none of the courts in America had any authority. Well, then what would you do if somebody broke into your car or stole your car or broke into your house? Right? I mean, that's why we've got these courts. And so we do try to be respectful of people and their rights. We don't always get it right. I'm not going to tell you we always get it right. But we do try. And we did try in your case. I'm not sure whether you agree with that today or not. And it wasn't my intention to lock you up to make you agree with me. It wasn't my intention at all. We only revoked your bond because you had refused to participate in the case. I think everybody in here, including you, is sorry that you ended up doing 69 days in jail. So, Mr. McLeod, I'm only going to sentence you to fines and costs here. In file 6748, on the contempt, we'll enter a judgment of contempt, order you serve 69 days in jail with credit for 69 days served. In file 6748, there is state costs of $68 on the felony count and $50 on the misdemeanor for a total of $118 in state costs. There's $130 in the crime victims assessment. There's court costs of $350. Order you serve jail for 69 days, credit for 69 served. And the judgment will order that your privilege to operate a vessel is suspended for 12 months from today's date. In file 6892, misdemeanor state cost is $50. Misdemeanor crime victims assessment is $75. Court cost of $350. And I'll again order you serve 69 days jail, give you credit for 69 days served. Not going to place you on any probation. And the total then fines and costs in 6748 is $598. In 6892 is $475. So the total on them both is at $1,073. If you need to set up a payment plan, you can do so by contacting Ms. Lale in our office. And as long as you're making reasonable efforts to pay that, there won't be any contempt citations or anything on that. Mr. McLeod, because we are entering a judgment in both those cases, you may file an appeal if you wish to the Court of Appeals to challenge your conviction or my sentences or both. If you wanted me to appoint a lawyer for you and you qualified, I would do so, but you'd have to ask me within 42 days. We're going to hand you some paperwork explaining that process and ask you to initial one copy for us so we have a record that we gave it to you. And one copy is for you to fill out if you want to take an appeal. Do you have any questions for me, sir? Okay, good luck to you.
Thank you, Your Honor.
Thank you.